On Wednesday, the House Energy and Commerce Subcommittee on Health and the Environment met to examine the Food and Drug Administration's role in enforcement of the Food, Drug, Cosmetic, and Device Enforcement Act. The Act provides for such things as truth in advertising of products, as well as an accurate and complete listing of product ingredients. The subcommittee chairman is Representative Henry Waxman of California. He's introduced amendments to the Act in the House. The amendments are meant to give federal courts and the FDA the authority to order the recall of products that violate the Act, and it would give the FDA subpoena authority to initiate an investigation into those products and to fine industries that violate the Act. Next, we will see Wednesday's hearing featuring a number of FDA officials, including Commissioner David Kessler, Director of Enforcement Alan Hoting, and regional representatives. We will also hear from food, health, and drug industry representatives.
Meeting of the subcommittee will come to order. This morning we will hear testimony on H.R. 2597, the Food, Drug, Cosmetic, and Device Enforcement Amendments of 1991. These amendments will provide the Food and Drug Administration with long overdue and long needed additional tools to enforce the requirements of the Federal Food, Drug, and Cosmetic Act. The bill would give the FDA the ability to recall defective, unsafe products, to assess civil monetary penalties, to subpoena witnesses and documents, to inspect records, to embargo defective products from moving in commerce while it obtains a seizure order from a court, and to destroy imported products that pose a danger to public health. The bill reflects the very significant contribution of Chairman Dingell and his staff, both on the full committee and on the subcommittee on Oversight and Investigations, which has built a record supporting many of the bill's provisions. While these amendments are critical to the effective and efficient enforcement of the Food, Drug, and Cosmetic Act, none of the ideas contained in the amendments is new. With one exception, every one of the authorities is already contained in the Act. The problem is that the statute is inconsistent. That inconsistency was documented in the May 1991 report of the Secretary's Advisory Committee on the Food and Drug Administration. The bill would provide the agency with these authorities for all the products that it regulates. Other comparable agencies also have these authorities. A report prepared by the Congressional Research Service for this subcommittee concludes that the enforcement authorities to be granted to the FDA under H.R. 2597 are apparently comparable to those granted to other administrative agencies. Many of them have been recommended by the Administrative Conference of the United States. Secretary Sullivan's Advisory Committee recommended that Congress arm the FDA with these enforcement tools for all the products that it regulates. Dr. Edwards, chairman of the Advisory Committee, reaffirmed that position in testimony before this subcommittee. The agency's new commissioner, Dr. David Kessler, who was also our first witness, has indicated in testimony before this committee that these new authorities are his, quote, highest priority, end quote. And just last month, Health and Human Services Secretary Sullivan testified before the subcommittee that he had approved draft legislation that would give the agency each of these authorities. In summary, the FDA operates under a 1938 law, which does not contain many important authorities that would routinely be given to a federal regulatory agency today. Given the broad support for many of these provisions in H.R. 2597, I look forward to hearing the testimony today. At this point, I'd like to ask unanimous consent that the applicable portions of the FDA Advisory Committee report and the full CRS report be placed in the record, and without opposition, that'll be the order. Before calling on our witnesses, I want to recognize members of the subcommittee for opening statements and to call on Mr. Dannemeyer first.
Chairman, thank you. I have a statement here that I'd like to ask unanimous consent be placed in the record.
Without objection, that will be the order.
I have also a couple of observations to make. You know, there are three principles that drive liberals in American politics. The first one is, if it moves, regulate it. The second is, if it grows, tax it. And the third is, if it makes a profit, investigate it. It must be doing something illegal. We have an illustration this morning with this proposed legislation, the application of that first principle, if it moves, regulate it. The regulatory load on American consumers and businesses today has reached awesome dimensions. We live in a free country and a free society, that claim is made, but regulatory authorities, well-meaning, well-intentioned, sometimes exceed common sense in terms of what needs to be done. This legislation, for example, now just think through this for a moment. If a person is suspected of violating the criminal drug laws of this country, before a law enforcement official would have authority to conduct a search of the premises of such a suspect, they'd have to go and get a warrant on the basis of probable cause that a public offense is being committed before being permitted to interfere or enter the place of residence or business of that suspect. The tragedy of this proposed legislation is the same standard would not pertain to a business person. The authority that would be given by this legislation to the FDA is absolutely awesome. The burden that they would have to comply with in terms of investigating an alleged violation is far less than the burden that is required to be observed in somebody violating the criminal drug laws, or rather the drug laws of this country. Now, that's nonsense. I admire the efforts of Dr. Kessler and his work as chairman of the committee, or rather the commission. I wish him well. I think you have sufficient tools under existing law to fulfill the responsibilities that repose in this agency, and I wish you well. And I don't believe that a case can be made for a need for additional legislation. Maybe it can. But let's hear the witnesses, and perhaps something will unfold that is of interest that needs legislative attention. Thank you, Mr. Chairman.
Thank you, Mr. Dannemeyer. Dr. Rowland?
I have no opening statement.
Mr. Sinai?
Mr. Chairman, very briefly, I think the hearing today is an attempt to try to balance sound public health with overregulation. And I'll look with great interest today to Mr. Kessler, who brings a tremendous amount of credibility to this issue. Regrettably, his testimony has been cut short. In fact, I cannot remember in my 13 years testimony this short on such an important subject. But I hope that he will share with us today those provisions in this bill which he thinks should be in there, and those provisions which should not be in there, and that will assist the committee in making a final determination of whether or not this legislation should even move forward. So thank you very much.
Thank you, Mr. Sinai. Mr. Bilirakis?
I have to open the statement, Mr. Chairman. Thank you.
Mr. Lent?
Yes, thank you, Mr. Chairman. I would like to commend you, Mr. Chairman, and the members of this subcommittee for their concern and commitment to a strong and effective Food and Drug Administration. As a member of the Oversight and Investigation Subcommittee, I'm well aware of the problems at FDA and the lack of confidence in that agency. Fortunately, with the addition of Dr. Kessler, much of that is now changing. Congress has an important role in assisting FDA in the enforcement area. In our evaluations of new enforcement tools, we must balance FDA's current ability to carry out its statutory duties against any undue burdens on the regulated industry. Unfortunately, an evaluation of H.R. 2597 shows that it fails this test. I have to agree with my distinguished colleague, the ranking member of this committee, Mr. Dannemeyer. In fact, it seems to me that this legislation would put in force the sort of investigatory procedures that Mr. Gorbachev is now trying to phase out in the Soviet Union. For example, the legislation authorizes the FDA to record any aspect of its inspections by photographs, videotapes, tape recorders. Now, this approach was long ago rejected by the Congress and FDA. During the 89th Congress in 1965,
the Senate held 3 days of hearings on the use of tape recorders and other electronic surveillance equipment by FDA inspectors. Shortly thereafter, the agency adopted a policy against any use of tape recorders during an inspection. H.R. 2597 authorizes the FDA to copy any company records and to impose new reporting requirements on companies. This provision raises the concern that proprietary or trade secret information upon which companies rely for their economic livelihood could potentially be compromised. It is unlikely that a significant benefit to public health will be realized by this risky provision. The bill also authorizes, and this is strange, FDA officials to carry firearms. Could someone please explain to me the need for an FDA official to carry a gun when inspecting a cereal factory? Mr. Chairman, these are just a few examples of the extreme nature of this legislation. Therefore, in its present form, I must oppose H.R. 2597, and I can only hope that the bill can be substantially modified. Thank you, Mr. Chairman.
Thank you. Mr. Hastert.
Thank you, Mr. Chairman. I'm certainly pleased to join you in welcoming Commissioner Kessler before the subcommittee to discuss the FDA's enforcement problems and certainly their policies. As the new FDA Commissioner, Dr. Kessler has agreed to take on a tremendous challenge, restoring credibility to the Food and Drug Administration. As we all know, the FDA has been besieged with problems, accusations of lax enforcement, internal corruption, and poor management have plagued the agency, and I think it's his brief tenure, I think Dr. Kessler has done much to turn that agency around. I think Dr. Kessler's recent actions demonstrate that leadership will be an enormous part of the battle to enforce the FDA Act. In my view, whether new authorities are needed at this time is questionable. Certainly the provisions of H.R. 2597 are far broader than I believe necessary to protect the public health. Specifically, I have serious concerns about the complete absence of important due process procedures. While FDA and other federal agencies should have the necessary tools to enforce the law, such authority need not and should not be unlimited. In addition, I'm concerned that H.R. 2597 repeals a number of important, certainly carefully worked out provisions concerning medical devices that were enacted into law just 7 months ago. And while I share the Chairman's often stated view that it's important that industry know what the rules are, I think it makes little sense to keep changing them. I do not understand what has really happened in the last 7 months to render these provisions in need of such major revision. And moreover, Mr. Chairman, I must point out that there is little incentive for Republicans to work out these types of provisions 1 year when they're simply going to be changed in less than a year later. For these reasons, I have very serious reservations about the content of 2597. I look forward to the testimony of our witnesses today. And as always, Mr. Chairman, I look forward to working with you and trying to work out these provisions. Thank you.
Thank you very much, Mr. Hastert. Mr. Dingell.
Thank you, Mr. Chairman. Mr. Chairman, I thank you and commend you for holding this hearing on H.R. 2597, the Food, Drug, Cosmetic, and Device Enforcement Amendments of 1991. It is a very important piece of legislation, and it's a part of the effort of this committee to streamline and modernize the Food and Drug Administration's regulatory powers, which are both sadly out of date and desperately in need of significant change and reform. The recent testimony of the Edwards Commission before this subcommittee highlighted the problems and the needs at FDA. And I want it known that I am very sympathetic with the plight of that agency. Hearings before the Subcommittee on Oversight and Investigations have revealed that the problems are indeed enormous and are in need of significant change. Those changes cannot be brought about without enormous increases in revenue, personnel, and funding, and without significant changes in the basic authority which exists at FDA. The Food and Drug Administration regulates 25% of the gross national product of this nation. It is the lead government agency responsible for protection of public health. And I will observe that its powers have proven, according to the hearings of the Subcommittee on Oversight and Investigations, to be grossly inadequate, very poorly administered, and grotesquely underfunded, and that it is literally incapable of providing the needed protections for the American people, and so much so that the confidence of the American public in that institution
is improperly placed and desperately in need of significant changes to justify public confidence. Unfortunately, the FDA has suffered through a long decade of neglect. Morale is low in the agency. Resources are thin. Personnel agency levels are extremely low. This has occurred at a time when the agency's responsibilities have significantly expanded. The U.S. food, pharmaceutical, device, and cosmetic industry continue to develop new and innovative new products, while American public demands greater assurances regarding the safety of these products. The FDA currently functions on a budget annually of less than $700 million, and it has to fight for every penny of that amount. And indeed, the Office of Management and Budget and the administration on a continual basis seek to cut back on the authorities and the abilities of that agency to carry out its responsibilities by constantly cutting at its budget and reducing the bone and muscle which are so necessary to that agency to carry out its responsibilities. After years of inadequate support, the capacity of FDA to discharge its basic public health mission has been seriously compromised. The administration's proposed fiscal year 1992 levels of funding will do little to alleviate FDA's resource problems. The agency is in serious need of substantial, new, and additional authorities and resources. I am exploring with a number of my colleagues, yourself included, Mr. Chairman, a number of legislative options to help FDA's ability to carry out its important regulatory functions. Some of these, and we are working on these at this time, are the Generic Drug Enforcement Act, to abate the massive problems that exist in an agency which regulates an industry which can best be described as a cesspool. The restructuring of FDA within HHS to eliminate meddling, interference, and improper behavior at HHS. Imposition of fees to enable FDA to go on a self-funding basis and to provide adequate agency resources without the constant, unending harassment and intimidation, as well as reductions in benefits and abilities of that agency to carry out its responsibilities. And last of all, the enactment of adequate statutory authorities to enable the proper enforcement of the Federal Food, Drug, and Cosmetic Act, a matter in which we are considering today. This bill is designed to provide FDA with the increased across-the-board enforcement authorities needed to carry out its multiple regulatory responsibilities. As matters now stand, the agency is operating under enforcement tools and procedures enacted better than 50 years ago. Its regulatory authority differs from one product category to the next. It is time that FDA's enforcement arsenal be brought into the modern world and be applied equally to all the products that it regulates. H.R. 2597 is a major step in the correct direction. This bill will provide for expanded recall, for seizure, for embargo, and subpoena authorities, similar to those which currently apply to medical devices. New administrative and civil and monetary penalties, increased authority for inspections and expanded access to company records and reports, new sanctions for violative imported products, and extended coverage of the Federal Food, Drug, and Cosmetic Acts to all goods which affect interstate commerce. I realize that there are concerns about parts of this legislation. I am disappointed that a large part of the industry has fallen into a position of myopic opposition. What is at stake here is simply public confidence, because public confidence is not currently justified either by the behavior of FDA, its budget, or by the law under which it functions. And if the public has confidence in FDA's ability to enforce Food, Drug, and Cosmetic Act, and that confidence is properly justified, then the public can have confidence in the safety of products regulated by FDA, and I believe that then manufacturers subject to that agency will prosper. I look forward to working with you, Mr. Chairman, and the industry during the coming weeks to perfect this legislation and provide FDA with appropriate tools to protect the public health and safety. And I look forward to a chance to ask a few little questions this morning.
Thank you very much, Mr. Dingell. Mr. Bliley?
Thank you, Mr. Chairman. I am pleased to participate in this hearing today on what I considered a very important topic: ways to improve the enforcement of the Federal Food, Drug, and Cosmetic Act. As the ranking Republican member on the Oversight and Investigation Subcommittee, which has been heavily involved in a number of FDA-related investigations, most notably the generic drug scandal, I am well aware of FDA's problems. However, this role has also given me the opportunity to see that proper enforcement of the Food, Drug, and Cosmetic Act depends in large part on the leadership of the Food and Drug Administration. In Dr. Kessler's brief tenure at the FDA, he has made it very clear that he intends to enforce the law. In the area of food labeling, Dr. Kessler's aggressive and highly successful challenge to a number of misleading claims illustrates the significant impact FDA can have under its current enforcement authorities. Product seizure, public pronouncements, and private negotiations initiated by FDA and the regulated industry have led to changes in label claims by many of the country's largest food manufacturers. These enforcement efforts have had a ripple effect, with many food companies voluntarily abandoning label claims. These actions demonstrate that a revitalized and credible FDA can be had in a large measure due to its leadership. I believe that H.R. 2597 goes too far without any benefit to the public health. I am particularly concerned that its uniform approach across all regulated industries does not make sense. The nature of the products regulated by the FDA varies significantly. Congress has chosen different regulatory approaches as a result. For example, before prescription drugs and most medical devices can be sold to consumers, manufacturers must obtain FDA pre-clearance that is designed to ensure the safety and efficacy of these products. Manufacturers must often submit clinical data to satisfy the legal standards incident to product approval. Foods, on the other hand, need not be pre-cleared, although various safety requirements exist. These and many other differences suggest that different products warrant differing regulatory approaches. One danger of blindly establishing new enforcement tools across the board is the burden that many of the proposed enforcement provisions would impose on FDA without any corresponding regulatory benefits. Mr. Chairman, I am unable to support your bill in its current form. However, I am willing to work with you, the administration, industry, and public interest groups to see if we can resolve our considerable differences to work towards our mutual goal of a strong and creditable FDA. I look forward to the testimony of our witnesses this morning, and thank you for the time.
Thank you very much, Mr. Bliley. Mr. Sikorsky.
Thank you, Mr. Chairman. The Federal Food and Drug Cosmetic Act of 1938 is one of the nation's most important health and safety statutes. It governs the function of America's first and foremost consumer protection agency, the Food and Drug Administration, the FDA. We're here to discuss the first comprehensive reform of that statute in 53 years. 53 years is a long time to wait to reform a law which Americans rely on to protect the public health. Congress recognized the need to modernize and amend the sections of the statute dealing with medical devices, first in '76 and then again last year. Now it's time to update the rest of the statute because it's pretty obvious, but it needs to be said. The food we eat and the drugs we take are just as life-critical as medical devices and much more personal and intimate to daily life in America. Yet I understand this enforcement bill, which supplies the FDA with the tools it needs, the tools it's requested to do its job, is being vigorously opposed by many in the very industries that the FDA is responsible for regulating. FDA asked for these additional authorities. The Department of Health and Human Services supported the FDA's request. The Edwards Commission, the Administrative Conference on the U.S., and others concurred that FDA's authority ought to be expanded. But it's curious. For nearly a decade, I've listened to many facets of the food and drug industry clamor that they want and need a strong FDA. Whenever there's an abuse in the industry or a problem highlighted in Congress, many times by the chairman of the Oversight and Investigation Committee, or by 60 Minutes or Primetime Live, industry claims that it's a few bad actors that need to be held accountable because they taint the reputation of the rest of the industry. And they're usually right, but they blame the FDA for failure to adequately enforce. But FDA tells us they don't have the ability to prevent or investigate a number of abuses under current law, pork shopping, for example. Few have argued against FDA being provided with more resources to effectively manage and carry out its statutory responsibilities. Now there's a piece of legislation that, through enforcement authority, helps to do just that, and it's met with real opposition. What can we conclude? This bill will not result in sweeping new authorities. It just gives FDA the tools it needs and requests to do its job. It will do a lot so that the FDA can protect human health as well as the USDA can protect animal welfare. If there are people in industry who are afraid that the FDA just might get the tools and resources that it needs to protect the public health, then they ought to be worried, because we're going to give them the tools and the resources they need to protect the human health. Thank you, Mr. Chairman.
Thank you very much, Mr. Sikorsky. Let me ask unanimous consent that other members, if they wish to, may insert an opening statement in the record at this point. We are pleased to welcome Dr. David Kessler, the Commissioner of the Food and Drug Administration, and his colleagues to our hearing this morning. As a number of our colleagues have already said, we I think are in agreement that we admire the work that you are doing at the FDA and trying to restore that agency to position it once held. We're looking forward to your testimony and to working with you on this legislation. I'd like to call on you now to proceed with your testimony.
Thank you very much, Mr. Chairman. I am here today to discuss the enforcement of the Federal Food, Drug, and Cosmetic Act. You know that I take the statute very seriously, and that enforcement is a very important mission of that agency. FDA has a strong record of enforcing compliance with the Act. Americans enjoy a high level of safety for products regulated by the FDA. Recently, the FDA's enforcement activities have been making headlines. We are moving in the right direction, and it seems to have captured the attention of American consumers across the country. We are proud of this, and I am proud of the FDA enforcement staff, particularly the people in the field who are serving the American consumer by their diligence. I know that today enforcement authorities are on your agenda, Mr. Chairman, and that the Congress has been thinking extensively about these matters. We in the administration are also carefully considering these issues. One of our concerns is that H.R. 2597 is too broad and may be reaching further than is needed. Our discussions are ongoing, and we consider this subject to be a high priority. On my left is Chief Counsel Margaret Jane Porter, and to her left is Catherine Kopp, the Associate General Counsel for Enforcement. On my right, sir, is over 100 years of experience in enforcement at the agency. Mr. Alan Hoding is Director of the Office of Enforcement. Mr. Jim Beebe is Regional Director of our Northeast region. Mr. Burton Love, Regional Director of the Midwest. And Mr. Ken Schellen is Director of our Detroit Investigations Branch. I hope their expertise will be helpful today. We will be very happy to try to answer your questions, sir.
Thank you very much, Dr. Kessler. Chair will now recognize each member for a first round of questions, and I want to start off with my questions. Dr. Kessler, you indicate that enforcement is a high priority for you, and you're looking at various proposals. We put forward a proposal that gives you more enforcement authority in a number of different areas. I was surprised that your statement was so short and somewhat restrained, because we'd already postponed this hearing once in order to give the administration a chance to formulate its position. And evidently the administration hasn't formulated a position yet, although as I understand it, you testified before us before that your highest priority is the need for new enforcement tools for your agency. There was a draft of a proposal that Secretary Sullivan told us on June 12th, a draft bill that had been transmitted from FDA to HHS and then up through others in the administration, which I think has many similarities to the bill that we've introduced, H.R. 2597. But what we don't have is an administration's position on each of these issues. I gather when you speak to us today, you are representing the administration and would give us the administration's views and not your own views personally. Is that correct?
Mr. Chairman, I certainly speak for the administration, and it's very important that we speak with one voice.
Well, I think it is too, and it's important that the legislation be worked on with this administration so that we can move it through and have the President's signature. So we do need to have the administration's position, your position, on the various items in the legislation. And I'd like to have the record to remain open for 20 days and ask that you present a position on each of the bill's provisions at that time, if you would. You're accompanied by several officials from the enforcement branch of the agency, and I'd like to ask you questions which you may want to direct to them. First issue is this bill would give FDA the ability to recall products that pose a significant health risk. Currently, the agency relies on its voluntary recall program when there's a need to recall defective products. Are there instances in the agency's experience where not having this authority has threatened the public health or seriously impaired the agency's ability to do its job?
Mr. Chairman, why don't I do as you just suggested and call on the gentleman at my side, perhaps Mr. Beebe.
I can give you a couple of recent examples. Recently found a firm to be shipping a product labeled distilled water, which actually contained isopropyl alcohol. Firm delayed a decision to recall the product for over 5 weeks. They continued to ship the product. This was a product labeled for use in preparation of infant formula. Another instance that's probably quite well known to many of the people here today, we had a nationwide recall of L-tryptophan. This came about because of reports of illness and even death. There are many firms involved, 430. 3 of these firms refused to voluntarily recall the product. The agency had to threaten local press releases and seizure before the firm would recall this product.
In other words, you don't have the authority to recall a product if it offers a threat to public health. You have to rely on the industry to voluntarily recall a product. Is that correct?
That is correct.
So you have to threaten to embarrass them in a press release in the local papers if they don't recall a product. I just can't see that it's unreasonable to say that the FDA, should they have the authority to recall a product, I think everybody assumed that you had that authority. Let's look at the embargo authority. Section 4 of the bill would give the agency the authority to embargo a product while it is obtaining a seizure order from the courts. It's my understanding that most states have this authority. Do you know if the authority given to state officials is similar to the authority that would be conferred on the FDA by H.R. 2597? And
Mr. Chairman, you're correct that the states do have embargo authority, and we rely on the states in many instances. Perhaps, Mr. Chellan, would you care to comment, or you know?
We have a case developing in Indiana right now where we've had to turn to the state for embargo of a couple of different products. There's a hog producer in Indiana which is feeding seed corn, not intended as animal feed, which has been treated with Captan, a fungicide, a methoxychlor, a pesticide, which is in the chlorinated hydrocarbon family. That's related to DDT. This hog grower has been feeding this seed corn, and our concern is that the tissue residues of the pesticides will wind up in the tissues of the hogs. It's a developing case, as I say, and we don't know exactly where it's going to come out, but we had to turn to the Indiana State Veterinarian to quarantine the hogs, and we also had to turn to the Indiana State Chemist's Office to embargo the seed corn.
Now, you don't have the authority to embargo these products on your own. You have to go to these other agencies for the embargo.
That's correct.
Now, is that a problem?
Yes, because these products could be shipped in the meantime and could get into channels of commerce and the food supply.
Let me go into the next issue, subpoenas. According to the report of the Congressional Research Service, there are over 200 statutes granting subpoena authority to federal agencies. USDA alone has 17 separate subpoena statutes. EPA, National Highway Traffic Safety Administration, the Consumer Product Safety Commission, the Federal Trade Commission, and OSHA all have subpoena statutes. I've been informed that in 1973, the agency asked Congress for subpoena authority in connection with investigations. In fact, the issue of the administrative subpoenas is so important that in 1974, the Administrative Conference requested that subpoena authority be placed in the Administrative Procedure Act so that all agencies would have that authority. First, Dr. Kessler, are you aware of any federal agency other than the FDA with significant regulatory responsibility over consumer products that do not have subpoena authority?
Mr. Chairman, I am not, but let me call on Catherine Kopp.
Mr. Chairman, I personally am not aware of such an agency. I would just qualify that by saying that the authorities do vary significantly from agency to agency.
But FDA has no authority at all for subpoenas. All other agencies have some authority, as best you can.
Mr. Chairman, FDA does have a very limited subpoena authority in conjunction with the medical device civil money penalty authority.
That's last year.
But absent that, that's right. And I would echo what Ms. Kopp said, that we can't say for sure we're aware of none, but we're certainly aware that a number of agencies have subpoena authorities.
Well, the industry has argued that the subpoena provisions in H.R. 2597 are too broad, yet the provision is modeled after the provisions in comparable statutes. The subcommittee has already supplied the agency with the citations to the subpoena provisions in these other agencies. I'd like to ask you to have your staff prepare an analysis comparing the subpoena provisions in those statutes with the provision in H.R. 2597 and to submit that analysis for the record within 20 days.
Mr. Chairman, we would be happy to do so.
Next, let's focus on the issue of whether the agency would need subpoena power in connection with any new authority to assess civil penalties administratively, an authority that we included in last year's bill in the medical device amendments. Subpoena authority would be available in any judicial civil proceedings. Do you agree that subpoena power is helpful to effective implementation of a civil penalty statute?
There is the issue of subpoena authority in adjudication, in rulemaking, and in civil money penalty proceedings. And I certainly think that one could argue that of all those cases, probably the strongest case would be in the civil money penalties. But again, our thinking is not complete by any means on this issue. But there are arguments that could be made.
Can you and your associates provide examples of cases where the agency's lack of subpoena authority stood in the way of its ability to do its job? Gentlemen?
We'd use subpoena authority in the drug counterfeiting cases, prescription drug advertising, device advertising, submission of fraudulent data and product approval applications, drugs, devices, food additives, color additives, economic fraud, and in drug diversion. There are many cases today before grand juries where subpoenas authority is issued there and used, and months go by before this takes place, and if we had the authority, we would be able to use it much earlier in the development of cases.
Well, what do you have to do to get the information if you don't have subpoena authority?
Can use the whatever the Act provides for now. We go to a grand jury and through the Justice Department.
Do you have any specific examples?
Well, there's a well-known case that took place in the last few years involving product labeled as 100% pure apple juice that contained very little apple juice, and we had to go to a grand jury in order to get the formula, the processing records, analytical records, and shipping distribution. And product, much of it was distributed and consumed by the American people.
Thank you very much. Mr. Dannemeyer, I took 10 minutes, and each member will have the opportunity to take up to 10 minutes if they wish to take that full amount of time. Mr. Dannemeyer?
Thank you, Mr. Chairman. Dr. Kessler, I'm going to make reference here to a raid that took place by the FDA. I understand you came to this job in January of this year, so this was not on your watch. But I'd like to just have you respond to this factual situation so you can tell me whether this is typical of enforcement activities of the FDA. On September 26, an FDA investigator appeared at Highland Laboratories performing a routine inspection. There was no hint of any forthcoming drastic action. However, on October 16, which would have been 20 days later, this particular business was in Oregon, I believe. Their place of business was raided by 11 FDA employees, 5 U.S. Marshals, and 4 heavily armed Oregon State Police. Trucks were drawn up to the Highland premises. A raid was allegedly conducted on the basis of a search warrant issued by the Portland Federal Court. No one connected with Highland knows to this day what the grounds for the search warrant were, the supporting affidavit being suppressed by the court. For approximately 12 hours, the 20 state and federal employees swept the Highland premises from front to back, removing virtually everything except the tables and chairs to the waiting trucks, including numerous items which were not even named in the search warrant. The trucks disappeared to an unknown location. Meanwhile, Kenneth Scott, Highland's president, and various employees under threats of violence were not permitted to enter the company premises. A few miles away, Mr. Scott's daughter was held for about 12 hours under house arrest. As of now, FDA has refused to disclose the grounds for the search or the reason why its tactics were employed. That company's out of business. Now, would you please explain to this citizen in this country why an agency of any level of government is conducting itself in this fashion? I realize that if, it wasn't on your watch, Dr. Kessler, and I appreciate that.
I know I have no knowledge of this case, so I can't comment. But the one thing that I can assure you that this agency stands for is to make sure before anything like that happens, is that it is absolutely imperative that there be probable cause of criminal conduct. Again, I can't conduct, but I can assure you that on my watch, that probable cause will be established.
Well, now let's just, maybe I'm missing something here, and maybe you can help me. And I appreciate, I've been on the side of law enforcement. I worked as a deputy DA and had policemen come in with affidavits, and I had to make a judgment as to whether we'd issue a warrant or conduct a grand jury investigation. We've all gone through that. Now, when you have a problem where it's alleged that a product is defective in some way, what is your existing authority?
Well, let's take you through that, and let me ask Mr. Hoding to do that.
We currently have the authority to enter regulatory establishments and to inspect those establishments in a reasonable time and a reasonable manner.
Mean that's during open business hours?
When the establishment is open, during regular business hours, we can enter and inspect in reasonable times.
Right.
We have the authority in the case of prescription drugs to examine all records associated with the manufacture or development of those particular prescription drugs.
Now let's stop. You mean at the retail place of business?
I'm talking primarily at the manufacturing place of business. I'm talking about any distribution warehouses. We have limited authority to enter pharmacies as an example, but we can enter pharmacies and we can inspect pharmacies, but our inspection authority does not extend to all records therein.
Limit, if you can, in your example and the responses to a retail establishment now. Supposing that the claim has been made that a product in a retail place of business has been improperly labeled. What authority do you have?
We have the authority currently to enter and inspect at a reasonable time.
And if you find that there is what? A product that's improperly labeled, what can you do?
If the article is improperly labeled, our investigators can collect samples. They can submit a report of that investigation to our headquarters. Our headquarters office, in turn, will review those particular claims on that label to determine whether or not that article is a new drug or whether or not the labeling for that product is false and misleading in some respect. If it's a significant matter, we may write a warning letter to the firm. If it's a more serious matter involving perhaps that the product is adulterated or does not do what it purports to do, the agency can initiate seizure action against that particular kind of product. If it's continuing kind of violation, we can exercise our other enforcement authorities as an agency.
Now, supposing you find a product that's improperly labeled, and you seize it and you make a judgment that it's true that it's improperly labeled, what do? You go back to that merchant and tell him what?
I'd venture to say that in 98% of the cases involving products that are mislabeled, we will issue some kind of letter to the firm. In most cases, firms will voluntarily make those adjustments in their labeling. So situations that we have where products are offered for purposes that amount to fraud. They make drug claims for products which in fact are foods. If there are those kinds of situations, why we, of course, may proceed with the seizure action on our first course of action. If the product is manufactured...
Describe how you go through a seizure action.
We proceed with seizure actions. The investigators collect samples. They collect documentation of interstate commerce. We have to establish that most articles move in interstate commerce before we can take an action. The paperwork from there is reviewed by our centers to ensure that our scientific position is valid. The paperwork is then prepared in our office, in our Office of General Counsel. The seizure papers are then transmitted from the FDA Office of General Counsel to the local Assistant United States Attorney's Office. The United States Attorney obtains a warrant from a local magistrate, and after this warrant is issued to the local federal district court judge issues the warrant, a U.S. Marshal will go out and actually seize the product.
Is there something in the existing law or process you have described that prevents you from performing your mission?
The problem that we encounter repeatedly in performing our mission is that we do not have the authority currently to inspect manufacturing formulas, the recipes for foods. We do not currently have the authority to inspect the analytical testing records that have been done on foods, for example, for salmonella or for listeria or for pesticides. We currently do not have the authority to demand and obtain from food or cosmetic manufacturers shipping records.
Let's come back to this process you've described for seizure. Going to the U.S. Attorney, presenting an affidavit of probable cause, getting an order from a court for seizure. Is there something that's defective in that process under existing law that you think needs remedying?
The problem with this entire process that I'm talking about is that it takes an extended period of time from the time that we first encounter the violation to the time that we are eventually able to attach or seize or arrest that particular violating product.
Is there something in this bill that will change the process we're now talking about?
There are provisions in the Waxman-Dingell bill that would permit the agency, for example, to detain or embargo, freeze, if you will, the movement of an article that our investigators have found to be adulterated.
Would you in that process have to get a search warrant or an order from a judge in order to do that?
No, we would not. Our investigators.
Don't you think due process in this country requires that you observe? I mean, in my opening statement, if it's alleged that somebody is illegally selling prohibited narcotics before a police officer can conduct a search, he's got to get a warrant of probable cause from a judge. Don't you think you should observe the same standard with respect to the operation of what some people claim is a legitimate business in this country?
I absolutely believe that we need to maintain due process. I believe we need to respect the rights of individuals. But at the same time, I think the consumer can reasonably expect that an FDA investigator can review the listing of the ingredients that are being placed in a food product.
Well, let me observe, sir, that, the Supreme Court Justice once observed, the government is to be feared the most when its purposes are benevolent. And so long as this member of Congress is privileged to sit on a policy committee in this institution, you're not going to get my vote to give an agency of the government, no matter how well-meaning, the authority on its own judgment, unilateral authority, to be both the prosecutor and the issuer of a warrant for taking property from a private citizen in this country. That's not America. That's a police state.
Thank you, Mr. Dannemeyer. Dr. Rowland.
Thank you very much, Mr. Chairman. Let me ask the question in a different way, pursuing what the gentleman from California has already focused upon. Do you now feel that you are hobbled in fulfilling your mission at FDA because of a lack of statutory authority?
Congressman, the agency can get the job done, and my highest priority is getting the job done. The issue that we're thinking about, and what I think this debate comes down to, is as we analyze, as we go through our thinking, are there provisions that would make sense, that would allow us to act more efficiently? In the end, FDA has a history, I believe, of getting the job done. Sometimes it takes a lot of resources and a lot of time. And that's what I think is at issue in almost all these issues. But I think the American people can go to sleep at night knowing that we do have the ability to make sure that products are safe and effective. The question is always, can we do a better job?
If you had more statutory authority, could you do a better job?
That's what we're looking at. I don't come here and ask for unlimited authority. We're looking at that question. I think also, Congressman, we could do a better job with our existing authorities. And as you've seen over the last couple of months, that is probably the highest priority to me, to make sure that we are using our existing priorities in the existing statute.
Well, in that respect, are you saying that if you had, for example, more personnel, could you better fulfill the authority that you now have? Or could we say that is one of the problems or not?
Congressman Rowland, I mean, as a manager, you always have to be, it's always true that more personnel would help. But let me say also that it's a two-way street. We're going to have to manage that agency better. And I think that is equally important, the management of that agency. I think that if we manage that agency well, we get the confidence of the Congress and the American public, I think I have every confidence that the President and the Congress will make sure the resources are available.
I have before me an outline of the FDA statutory authorities. Let me just ask, for example, with reference to inspection of records, this outline indicates that you do not have the authority for the inspection of records in biologicals.
Let me ask counsel to talk about the specific provisions, if I can, Congressman.
Mr. Rowland, I think we need be a little bit more specific about the extent to which we don't have records inspection authority for biologics. Biologicals are considered to be drugs under the Act, and there's already fairly extensive inspection authority for prescription drugs.
So that is that you would be able to inspect the records of those companies that are manufacturing biologicals expeditiously. You don't need any additional authority to do that?
Mr. Chairman, I don't think, as Dr. Kessler indicated, we are currently in the process of reviewing the extent to which we need additional authority with respect to any of the matters at issue here.
But biologics fall within the prescription drug category. As Mr. Hoding reminds me, we do have the authority.
If you were to get this additional authority that is proposed under this legislation, what is the potential for abuse or overreacting under this additional authority that may be granted? Would that be?
I don't believe, Congressman, that you should grant us any additional authority that would allow that to happen. I think that any additional authority should be well circumscribed and assure due process for those who those provisions apply to. I think that that's a basic principle that should guide us in our thinking.
I'll yield to the chairman.
Which my good friend from Georgia is referring. Administrative recalls, biologics, limited authority.
I'm sorry. I thought that the issue was records inspection of documents.
Huh.
Congressman Dingell.
That was, but if you go further down that line, what the chairman is pointing out is also listed there, so maybe you want to address that.
I yield back. I thought we were talking about recalls.
I think the question was about inspection.
So you don't...
Well, if the gentleman yield here, I'm looking here. Inspection authorities for record inspection, biologics. No authority according to what
the authority under biologics is contained under the Federal Food, Drug, and Cosmetic Act. The Biologics Act itself does not specifically reference inspection authority.
How much authority?
But most of the biologics, in fact, all of the biologics products that I'm aware of are drugs. They are prescription drugs, and as such, we have complete inspection authority with those articles.
Thank you. Thank you.
So you're not particularly concerned then, Dr. Kessler, under additional authority that you may have under this legislation that there would be that potential for overreacting or abuse?
As I said, I think that in our thinking it's very important to any additional provisions should be narrowly written so that they don't allow abuse. I think that's very important, and if that guides us, we should not have problems.
I suppose one of the things that I'm concerned about is that someone could make a decision in reference to any aspect of the legislation insofar as record inspection or embargo that may not really be qualified to make a determination about what should be done. I'm concerned about the possibility that some person would be in a position to cause some real difficulty for an industry that should not happen.
Again, I recognize that even the best strong statute involves individual judgment of those implementing it. And it's our job to make sure that the systems exist, Congressman, so that no one person act for and by themselves. That any decision that would be made by an investigator gets carefully scrutinized by that person's supervisor. Can't have too many layers, because then we can't function efficiently. But I think that we have to make sure that the systems are in place for whatever authorities Congress so enacts.
So I take it at this point that your decision has not been made about this particular legislation and whether or not you need the additional authority that's granted in this legislation.
Our thinking continues, sir.
Thank you, Dr.
Yield to me?
I'll yield to.
I don't want to interrupt your questions, but what we're talking about in terms of authorities for the FDA is to be able to go out and inspect records and inspect formulas that are used by food manufacturers or drugs or others, medical device people, to be able to subpoena information so you'll know that the law is being adhered to be able to recall a product that turns out to be unsafe, to be able to embargo or detain a product that you know to be a health threat, to be able to impose civil penalties as opposed to only go and take the product off the market, but to try to get the manufacturer to do what's required of them. These are the kinds of things we're talking about. I just wanted to point that out because when we hear the rhetoric of a police state, that's such an extreme kind of statement. We expect the FDA to protect us from drugs that aren't safe or drugs that are not effective or medical devices that are unsafe or ineffective or foods that are going to poison us or cosmetics that may do harm or all these different areas. In order to do your job, you've got to be able to get the information from the manufacturer or supplier or retailer as to what's in these products and how they're being manufactured and distributed. Isn't that what we're talking about, Dr. Kessler?
We are certainly, I think we all share the same concerns that anything that we come up with or Congress comes up with, I'm sure will be adequately with due process. We're not talking about a police state here.
So due process, you're not accusing anybody of a crime. You're just trying to make sure that the product that's distributed is not going to be unsafe to people using that product.
That is the mission of the agency.
If there's a crime, then that'll proceed with the usual criminal procedures with a burden of proof that's beyond a reasonable doubt. But you shouldn't have to be held to a reasonable doubt standard before you can take any action that may well be poisoning lots of people in this country who think that their government is protecting them from unsafe products. Isn't that correct?
We certainly, protection of the public is the most important thing we do, and we have to do it expeditiously.
Thank you, Dr. Rowland. Mr. Bilirakis.
Thank you, Mr. Chairman. Dr. Kessler, we all realize that the focus of this hearing is certainly on enforcement, whether there's a need for additional enforcement procedures, basically H.R. 2957. But nobody has really gotten into what I've always, I guess, considered the principal role of the FDA, and that is the approval process, the approval-disapproval process, particularly of new drugs, getting new drugs, if you will, to sick and dying people who need them. And I realize that the role is a broad one. There isn't any question about that. But let's get into what do you see as the primary role of the FDA under current law and in the process, because I think it's generic, if I may use that term. It's generic, it's general, but I think it's fundamental to the role of FDA. And what areas would you like to see, if you were king, if you will, or if you were chairman of this committee, which sometimes is synonymous to being king? What areas would you like to see as priorities for the commission? What would you were offered the job of the leader of FDA. You're a medical doctor. What would you prefer to see as the priorities? And how do you see the role of the FDA now?
We're talking generally. We're talking about drug approval. We're talking about enforcement, or
what would you prefer? Where do you think the emphasis should be? This hearing is on enforcement,
right?
And previously, we've held hearings under the capable leadership of Chairman Dingell on generic drugs and some of the problems that ensue there among some of the FDA employees and things of that nature. But we as elected members of Congress receive some horror letters from people who a member of the family has Alzheimer's or Parkinson's or cancer or something of that nature, and the drug is being supposedly tested and it just lingers and just drags through the FDA. They talk about going to Mexico and going to another country to get hold of some drugs that they feel would be helpful. And in the meantime, we keep emphasizing this business of walking into a business sometimes without adequate cause. I guess that's subjective, and inspecting distilled water, which I'd sure be curious to get a little more detailed on this distilled water situation and how you found out about it and what caused you to go into it and how much of your resources has gone into the distilled water when, in fact, there are people out there who need these drugs so desperately.
Congressman, that's helpful. I think whether we're talking about in the area of enforcement, or whether we're talking about the area of getting safe drugs and new drugs onto the market for
I guess I'm saying that, to my way of thinking, the principal role of FDA, in my mind, has always been basically getting new drugs onto the market that are needed by so many dying.
Absolutely. There's a shift occurring. And let me tell you a little about that.
Okay, great.
Back, I guess in the 1960s or so, post-thalidomide, post the new drug amendments, I think that there was a general sense of the mission of the agency was to keep unsafe drugs off the market. And that really resulted in certain behaviors on the part of the agency. The agency that I have come to, and then I am impressed, and I think you will see it this week in the grappling with THA and the angst and trying to come to a decision on THA, and later this week a very important advisory committee on DDI. I think we have come to recognize that the mission is not simply keeping unsafe drugs off the market. that we have an affirmative mission to make sure that safe drugs are on the market, especially for life-threatening diseases. And that's a very, my job is to provide the direction for the agency. Under our current thinking is exactly to do that. The people in the antivirals division working right now in ways that they've never worked before. We have an application for DDI that was submitted sometime in April. We're bringing it to an advisory committee this week. 3 months. We've never heard of that before. Usually we're talking about several years. There is an aggressiveness, there's a commitment, and there's also the compassion, because we recognize what's at stake here. It is a leadership issue, and it is very much a management issue. And I think that applies not only to the drug approval process, but to the enforcement process. In drug approval, we need, for life-threatening diseases, we need to be turning over protocols in a matter of weeks, and we need to be acting on applications within months, not years. And that's where our commitment lies.
All right. Can you do a better job at that with the current staff that you have, with the current resources that you have?
There's no question that I believe that the most important thing, that the real story is, as you just hit it on the head, I believe that the standards that Congress enacted are wise standards. I think that the safety and efficacy standard, as they are in the Food and Drug Act, make a lot of sense. If we want to speed up the drug approval process, there is no magic bullet. Where the answer really lies in the intensity of the effort. We have more medical reviewers working on that DDI application than ever before. They all have a part, and they will all be presenting on Thursday. And that intensity of the effort and the resources we have available really, in the end, will make the difference, as well as the overall commitment.
All right, but you talk about intensity, sir, and there's only, as we oftentimes tell our children, money doesn't grow on trees, and there's only so much there, and you can be afforded only so many dollars and so many staff members. I understand in your 1992 appropriations request that you include, your request includes 322 additional staff for enforcement initiatives. I don't know what you've requested in terms of additional staff for purposes of drug approval. And I'm not trying to belittle the role of enforcement. All right, that's our part of it, and we as consumers are very grateful for that. But when you dilute your resources, which are so very, very limited, I just wonder whether we're placing our emphasis as on really where emphasis should be placed. Are we placing more emphasis on enforcement and going and checking into this distilled water situation, if you will, and I haven't heard the details on that, so I don't really know how horrendous that situation is. Are we more concerned about fraud as far as labeling is concerned and things of that nature? Are we more concerned about safety? Are we more concerned about approval of drugs that can go to people who are so desperately need them?
Congressman, I think we have to have both of those issues the highest level of concern.
Gentlemen, yield to me?
I certainly would, Mr. Chairman.
Just following on that point, could I ask you and those who are with you who have been involved in the field on these issues, if you had some of these authorities, would it mean that you'd use less resources or you use them more effectively? In other words, do you have to sometimes have your personnel go 5 or 6 steps when, if you had the ability to get the information directly or to act directly, it might have saved some of the time and troubles?
Mr. Chairman, that's the exact kind of thinking that we're doing in the exact kind of analysis. Because we really do have to find better ways to use the resources we have. The budget, the 91, 92, there are reasonable increases in there. But we're going to have to find better ways, and that's the kind of analysis that we're undertaking in those.
Well, for example, if you have to go and ask the state to bring an action to get you the information or to seize a product that you know is unsafe, then you have responsibility protect the public from. And then you have to get the state involved, so you get your personnel to ask the state, or you have to then ask the industry to recall a product voluntarily, and you can't act if they refuse to do it voluntarily, so then you have to go get your lawyers to go to court and to take 5 other... Isn't this the kind of thing we're talking about?
Absolutely. It's not a very efficient system.
And so you need more authority to be more efficient and use your resources more wisely in the enforcement aspects of the Food and Drug Administration.
That's what we're looking at.
So what we're saying, Mr. Chairman, is that if this piece of legislation passes, that we will see a better intensity insofar as drug approvals are concerned?
I would hope, no, I don't know about drug approvals alone, but I would hope that the FDA would use its resources more widely, both in the approval process and the recall, assuring the public on safety and efficacy of drugs and medical devices, and safety on food. That's our goal. Now let's look at the details and work it out.
Thank you, Doctor.
Thank you, Mr. Bill Marcus. Mr. Dingell?
Dr. Kessler, welcome to the committee this morning. I was curious, during the time that the FDA was going through these vast gyrations with regard to the recall in the case referred to by the chairman and by Mr. Waxman, if the company concerned did not accord with a voluntary recall, the shelves would continue to empty, the product would continue to be sold, and the public health would continue to be threatened, would it not?
Yes, sir.
So how long would it take you to get around to the point where you could get an effective recall under the terms that you felt were necessary to protect the public interest, to prevent the sale of an unsafe food, drug, or cosmetic?
I think that most instances we eventually get it, but sometimes it takes very long.
Well, very long is how?
Well, it depends on the specific case, Chairman.
Months, weeks, days?
Certainly can be all those.
Okay. Now, I have a couple of documents I'd like to have shown to you, Doctor. The first is a memorandum of a telephone conversation between one Adam Trujillo, the acting director of the Office of Enforcement, and attorney for Sidmac Laboratories in East Hanover, New Jersey. The issue involves a Class 1 recall of chewable vitamins designed for children, where the company used a laboratory that provided a false analysis. That false analysis was not checked. The laboratory's work was not checked. The result was that 20,000 units of vitamin D per tablet was labeled as 400 units per tablet. According to Mr. Trujillo, the attorney for Sidmac threatened to be nasty and to contest the recall unless the agency removes Sidmac from the compliance alert list. You have that before you, do not? Ask this be inserted in the record, Mr. Chairman.
Without objection, that'll be
the second document is the agency's formal response to a June 1 letter from Sidmac requesting the recall to be reduced to Category 2, wherein John Taylor, then Associate Commissioner for Regulatory Affairs, points out how serious the health hazard was. He cites a May 24, 1989 press release by Commissioner Young that states as follows: "Use for several weeks might produce an elevation of blood calcium levels that could damage the kidneys and, if not recognized and corrected, lead to death. Thus, there is a strong likelihood that the daily use of the product as labeled, 1 tablet per day for 100 days by a 3-year-old child, could cause serious adverse health consequences." Do you agree with that statement?
Again, I've not studied the specific facts, but I think that from the quick reading, I certainly would.
Well, let's explore this. What is the difference between a Category 2 and a Category 1 and a Category 3 recall?
We have the expert right here, sir.
A Category or Class 1 recall is a recall involving an article which may cause death. Or
now, could this level of vitamin D cause death to a 3-year-old?
I don't know that vitamin D will cause death, but it can cause serious injury to an infant.
Okay. Now, what is Category 2?
Category 2 recall is an article that presents a health hazard, but it's not a permanent health hazard. It typically is a reversible kind of situation and does not represent the highest level of risk, as does a Class 1 recall.
What about 3?
Class 3 recall represents an article that is in violation of the Food, Drug, and Cosmetic Act, but does not represent a public health risk.
Now, even though the press release was put out on May 24, the agency and the firm are apparently still haggling over the extent of the recall as late as June 23. Is that true, gentlemen, ladies?
As I recall, in this situation, the firm contested our classification of that recall. They felt that we had placed it at too high of a level. They felt it should have been a Class 2 recall. I think there are typically concerns about product liability and other issues which do not really affect the Food and Drug Administration.
No, but they do affect the health of the individual who might be using this. The whole process started in June of '89. It continues in July of '91. The goods are still on the market, still on the shelves, still being sold.
And of major concern to the agency.
Beg pardon?
And of major concern to
and
the
you have
agency.
no authority. You have no authority either to embargo or to cause the recall of this kind of item. Is that correct?
That's correct, sir.
Well, maybe I should assume that you would look with kindness on the recall provisions of the bill that Mr. Waxman's introduced.
We want to get product. We want to stop this kind of behavior.
Well, you can't stop it if you don't get the legislative authority, can you?
There's no way that we can require mandatory recalls without it.
Now let's go further. In the case of the Class 1s, the Secretary may already have the authority to recall, but clearly the firm has a level of appeal because the documents indicate that they're still debating at least the classification recall, and there are other documents in the files of the agency that had not been completed by the 23rd of June. Is that right?
Yes, sir.
Now, would you submit for the record the dates on which SIDMAC Laboratories was put on the alert list and maintained on that list?
I would be happy to.
What is the alert list?
The alert list is an informal kind of mechanism that we have in existence in the agency to alert our new drug reviewers that there's a problem with the quality controls of a particular establishment, and that we ought to carefully assess that before we take final action on those applications.
It also informs your field people that this is a company that might need a little extra watching, does it not?
Well, most typically our field people call problems to the attention of our headquarters offices.
Will you supply those items for the record, please?
We would be happy to, sir.
Mr. Chairman, I would note that we have been working from FDA enforcement authorities. This document you are familiar with, I assume, ladies and gentlemen. That is from the Edwards Commission, is it not?
Yes.
It cites the authorities. Going down with regard to foods, it says you have inspection authorities. You have none with regard to containers, commercial testing laboratories, photographs during inspection, records copying. You have indirect authority for collecting samples. You have no subpoena authority. You have limited establishment registration. You have no presumption of interstate commerce, which causes you vast confibulations and dancings and wavings of the air and sawing of the air before you can establish that you have jurisdiction to deal with that question. Is that not so?
Certainly creates serious problems.
You also have no requirement for reporting to the Food and Drug. You have limited administrative recalls with regard to food. You have no authority for detention authority. You have limited ability to address the question of imports. Is that not so?
That's correct, sir.
As a matter of fact, when they import a good, food, they may simply re-export it, let's say, from the port of Detroit, and re-import it through the port of Buffalo and sell it again in the markets of the city of Detroit. Is that not so?
Yes, sir.
And you have no authority to deal with the embargo question.
That's correct.
You have no authority for civil penalties. You have no authority for court-ordered civil penalties. Is that right?
That's correct.
That's correction food.
No, I'm sorry. There is, in those categories that you've so identified, that's correct. In medical devices we have.
Okay. Now let's go to some other questions here. With regard to your recall authority, according to the documents obtained by the subcommittee from your offices during the summer of 1988, your Denver office and compliance office in the Center for Drug Evaluation and Research argued with the Pharmaceutical Basics, Inc., PBI, for a full 6 weeks over the dimension of a recall on what would involve some 50 million carbamazepine tablets. Carbamazepine is a very narrow-range therapeutic drug used by epileptics. While the dispute was going on, the agency received reports of 22 seizures and 2 deaths from epileptic patients who were on the generic carbamazepine produced by PBI. The agency did not conclude a causal relationship existed between the seizures and the drugs. Nevertheless, FDA did determine that it was unauthorized regranulation of the raw materials that had caused the dissolution problems with carbamazepine. Is this correct?
That's correct, sir.
Now, this same firm shut down all tablet and capsule production because of the discovery of massive fraud, false statements in its records this past January. It recalled its carbamazepine again in March at the agency's urging, but has yet to recall any of the other 60 drugs plus that it markets. Is that correct?
That's correct.
Now, you sent on May 1 of this year PBI a letter requesting recall of all their production from their Denver facility. Is that correct?
That's correct.
Now, this is a facility that was guilty of severe disregard for your good manufacturing practices. Is that not so?
Yes, sir.
And and you had a number of other questions about manufacturing practices, about the way that they conducted the business of producing, manufacturing, testing, and safeguarding the particular commodities that they manufacture in that facility. Sir. Is that correct? Now, in fairness, the company should be noted that their attorneys inform us that they've offered at least since June 24 to recall as many products as FDA deems necessary at whatever level they deem necessary, presuming retail as well as wholesale. But they're resisting the recall because the FDA wishes to classify it as a Class 2 rather than a Class 3 recall. Is that right?
Yes, sir.
And the company has product liability concerns. Now, nevertheless, the fact is that the product is on the market and presumably is being sold on a daily basis 2.5 months after FDA formally requested the recall in writing. Is that right? And people are still being subjected to the possible risk of a drug for epileptics that is not properly formulated and has the potential to create either seizures or deaths. Is that right?
And a major concern. I don't know the safety issues, Congressman, but of major concern to us.
Well, you've got people who've died and people who've had seizures after they were using a drug which was supposedly addressed at their particular condition, which was supposed to be safe.
Yes,
is that
sir.
right?
Yes, sir.
This is enough to indicate severe warning to you, is it not, Doctor?
Yes, sir.
Now, in fact, PBI has agreed to withdraw all 47 of its ANDAs, and FDA is asking for 63 to be withdrawn. And it is, however, the fact that they have not even recalled the products from the 47 ANDAs. They concur have been tainted by fraud or false documents. Is that right?
Yes, sir.
Now, all of these 47 that we're discussing are tainted by fraud or false documents. Is that not so?
I believe so.
I've used more than my time. I thank you, Mr. Chairman.
Thank you very much, Mr. Dingell. Mr. Lynn?
I have a few more questions on this.
Do you want to ask unanimous?
Thank you, Mr. Chairman. Dr. Kessler, first of all, I want to welcome you to the committee. I learned this morning that Dr. Kessler was a constituent of mine for some 20 years on Long Island. So welcome before the committee and welcome to Washington. Doctor, I'd just like to take you down a somewhat different path. Let's assume that instead of being the new commissioner of the Food and Drug Administration, you had been appointed the new commissioner or leader of the Drug Enforcement Agency. And let's assume that instead of being worried about pesticides on fruits and carbamazepine and some of the other problems that you're facing today, you were worried about things like cocaine and speed and marijuana. And you were before a committee of this Congress. It wouldn't be this committee because we don't have jurisdiction. And someone on the committee had proposed a bill to help you as head of the Drug Enforcement Agency do your job. So that if you saw a building, or one of your people saw a building that you thought contained a stash of cocaine or some other contraband drug, that they wouldn't have to go to a judge to get a subpoena or a search warrant. They could just march in there with their gun on their hip and they could embargo that contraband. And then after they had done that, another provision of this law that was being proposed provided that your drug enforcement agency could act as the judge. And your drug enforcement agency could conduct the trial in-house and find a guilty verdict and impose substantial penalties, money penalties, against the people that had been in charge of that stash of contraband. Probably you wouldn't get, that bill wouldn't get very far, because civil libertarians would be screaming all over the place. Some of the people who are pushing this kind of legislation before our committee, who won't vote for the crime bill because they feel that it violates civil liberties and goes too far. You probably wouldn't, that bill probably wouldn't get very far, because it would offend traditional American principles of due process that have come down to us from the Magna Carta and before. But yet isn't this legislation that we're dealing with here today, transferring you over now to the Food and Drug Administration, and instead of the Act being the Controlled Substances Act, the Act is the Food, Drug, and Cosmetics Act, asking for the same kind of powers, very, very drastic powers that offend the sensibility of many, many civil libertarians, that should offend the sensibilities of civil libertarians.
At this point in the hearing, we experience technical difficulties with our power source. Our coverage resumes about 30 seconds later, but we continue to experience video problems throughout the last 6 minutes of this hearing.
Let me say, if this bill pertained to the Drug Enforcement Agency, and I was sitting on a different committee, I think I could support, I think the problem of drugs and cocaine and narcotics and that sort of threat to our society is so great that I would be willing to vote for this kind of legislation if it pertained to the Drug Enforcement Administration. But until we do that, until we take that step there, I don't think our grocery shelves present anywhere nearly the threat to America as does the threat of drugs and narcotics. So I'm a little bit, yeah, I'd be happy to yield, because I know you're going to answer the question that I have, which is why do some of the people who are sponsoring this legislation not want to do this with respect to drugs and narcotics? Mr. Waxman, I'd be happy to yield.
Well, thank you very much for yielding. I believe that the drug enforcement agencies, over which this subcommittee has some jurisdiction, has all the authority now to issue subpoenas, to go in and inspect. If they think a manufacturer is manufacturing a dangerous drug, the Drug Enforcement Agency can go in there and inspect that facility. I think there's a difference between a criminal trial and an agency doing its job and having the enforcement tools to do its job. We're not proposing any authority to the FDA that isn't already at a long list of other regulatory agencies, and there's never been a constitutional civil liberties question about it. I think they need the tools to do their job, and I think the Drug Enforcement Agency needs its tools, except for being able to issue civil penalties. I don't think there's an authority we're giving the FDA that the DEA doesn't already have, and if they don't have it, let's make sure they have it as well.
Does the DEA have the authority to find the guy guilty and impose a sentence?
FDA doesn't have the authority to call a man guilty and impose a sentence.
So this bill gives them that authority.
They can stop the distribution of a product that's unsafe or ineffective, and they should be able to do that.
And this bill...
And they can refer for prosecution somebody who is violating the law, and they should be able to do that as well.
Can this bill not effectively destroy a business when you can hold a product for 30 days?
Is that what this is all about? You don't want to destroy a man's business, even if he's producing a product that the FDA determines is a violation of the law and may be a threat to public health? Are we saying the civil liberties of a businessman is so important that the public health ought to be put at risk? Nobody's affecting their civil liberties. We're saying that the agency that can review before a drug manufacturer can go to market with a legitimate drug, they have to submit papers to show the drug is safe and effective. That's a restriction on his ability to market a drug, and we have to make sure those marketing tools are there for the FDA. Let me just ask the
gentleman, this could be helpful to the discussion. Doesn't this legislation contain provisions which would allow an FDA inspector to go into a delicatessen or a grocery store or a drugstore and seize a product and embargo that product?
If it's going to poison people, why shouldn't they be able to do that?
All right. But you would not give that authority to a DEA inspector.
To go in and seize any illicit drugs? Absolutely, they have that authority. They should have the authority.
The DEA does not need to get a subpoena before it goes into a building and seizes illicit drugs. Haven't convictions been thrown out because a search warrant was not obtained?
You're talking about the conviction of the criminal, which is a different standard than getting a product seized by the government. If the government sees that there's cocaine or heroin or some other product like that that's illegal, they can go in and seize it. Now, whether the person's violated the law is something then up to the courts.
Reclaiming my time, I think you will find that the Drug Enforcement Administration and its agents do not have anywhere near the summary authority to act as prosecutor, judge, jury, and finder of the penalties that this bill would give to the FDA. Now, if you'll vote for that, for the DEA, I might change my position on this bill. But until we come to that point, I think the problem, the scourge of drugs and cocaine and other problems we have in this country, if we're going to start chipping away at due process and the rule of law, we ought to start with the drug purveyors before we bother with the guy that runs the local delicatessen or pharmacy or grocery store. I frankly don't feel anywhere near as threatened in the giant food market as I do when I go by a certain corner in my neighborhood where I know that narcotics and cocaine are being distributed.
Gentlemen, permit? I would certainly support the authority for the Drug Enforcement Agency to do anything they need to do to stop illicit drug traffic. But I guess the question of Dr. Kessler is that when you say you need more enforcement authorities, is it to go after a mom-and-pop delicatessen to shut them down without civil liberties? Or is it to make sure that if there's an adulterated product that's going to poison people, that product can be taken off the market as quickly as possible so you protect innocent people from that kind of harm?
Certainly the public health areas that have the highest priorities.
But this bill would give your people the right to go into not just big factories and poultry slaughterhouses, but also into pharmacies and supermarkets. Is that not correct?
Our jurisdiction crosses all those boundaries.
My time
and
is
that
up.
jurisdiction is there right now, doesn't it?
Yes, Mr. Chairman.
So you can go in if there's a problem now. The only thing is you can go in now, but you can't do what's going to be necessary to protect the public because you don't have all the enforcement tools to do it.
We can go into all those facilities.
Now that we solved that problem. My time is up. I heard the bleeper.
Thank you, Mr. Lent. We are being summoned to the House floor for the purposes of a vote. We're going to take a brief recess to respond to that vote, and then we'll come back and pursue further questions with you, Dr.
Thank you, Mr. Chairman.
Okay. I'll do whatever you want.
Meeting of the subcommittee will come to order. Mr. Sikorsky, I want to recognize you next.
Thank you, Mr. Chairman. Let me just make a comment that I'm amazed that the FDA tells an orange juice company to make fresh squeezed, reasonably fresh squeezed, and everyone gets all nervous about it. And the chairman of the committees have a piece of legislation that basically gives this important consumer protection agency the authorities that most administrative agencies for the federal government has, and simply recall or to freeze so it doesn't have to be recalled dangerous food and cosmetics and drugs from interstate commerce. And boy, everyone gets all nervous, and all these public officials become instant civil libertarians. And I just comment that as soon as EDB gets in cake mixes or there's Aldecorp or something on a melon, those public officials run to kick the Food and Drug Administration in the backside for not doing something before that. Having said that, maybe you can identify for me the people with you again, Dr. Kessler. So I know you have Midwest
Sure.
region. Okay.
Again, we have senior enforcement officials of the agency. To my immediate right is Mr. Alan Hoding. He is Director of the Office of Enforcement. Mr. Jim Beebe, who runs our Northeast Division. Mr. Burton Love, who runs our Midwest Division. And Mr. Ken Schellen, who is the head of our Detroit Investigations Branch, sir. I'd be happy to introduce counsel. Margaret Jane Porter is Chief Counsel for FDA, and Catherine Kopp is the Associate Counsel for Enforcement.
Thank you, and welcome you all again. One of the let's talk a little bit about the minor issue of trade secrets. One of the arguments cited for against giving you a subpoena authority that works, and also against giving the agency broader inspection authority, is that the agency might reveal formula or trade secrets. You handle trade secrets of the most sensitive billion-dollar kind on a regular basis today, and what's your experience been?
I think Mr. Hoding probably has the most experience with the issue.
The agency handles approximately 40,000 requests for information from our files per year under the Freedom of Information Act. All of the trade secrets, the manufacturing processes, the formulas, any financial data, personnel information is exempt under this statute from disclosure. FDA employees are subject to severe criminal penalties if they release any confidential information or trade secrets which are entitled to protection.
Are you aware of any instance where FDA has revealed trade secrets?
No, sir, I am not. We're very proud of our record in terms of handling these 40,000 requests per year for each of the last 10 years, and I cannot think of a situation in the last 5 years where we've had any really valid allegation of the release of a trade secret.
Thank you. On civil penalties, Dr. Kessler, the Department has administrative civil penalty authority in connection with which programs?
Mr. Sikorsky, the Department already has civil money penalty authority largely in the Medicare and Medicaid programs. My understanding is that there are at least 50 provisions in the Social Security Act that provide for civil money penalties. I don't have an exact count. We could easily submit it for the record. And as you know, there's civil money penalty authority for devices now under the Food, Drug, and Cosmetic Act.
And also HCFA has it for the clinical laboratory programs.
There are also civil money penalty.
You got CLIA and the medical devices and Social Security and Medicare and Medicaid. Now, how would it make it this situation better in the other parts of your authority if you can do civil penalties? If this would be something that sometime you would want to do.
Thank you, Mr. Sikorsky. I think that there is a concern that the provisions that we currently have can be draconian. Criminal prosecution is as serious a remedy as one could have under the laws of this land. And I think in our thinking, we have to factor in that there may be violations that don't rise to the level of criminal prosecution, and yet we need to take appropriate action. We have some other tools. We have seizure. We have injunction. We have several administrative remedies, but it may be a valuable tool.
So if you're concerned about federal deficits, if you're concerned about civil liberties and not forcing someone into a criminal process that may be inappropriate or unjustified, if you're concerned about the agency efficiently using its time, the burden of proof in a criminal prosecution is much greater than in the civil proceeding. If you're concerned about a host of things, you'd support supporting civil penalties. On inspection authority, Section 7 would give the agency the ability to inspect records of the industries that it regulates. The food industry, prominent in Minnesota, but the food industry generally has opposed granting the agency additional inspection authority. Can you give us some examples of how additional inspection authority would assist the agency in protecting public health?
I think that, Congressman, I think we can perhaps give, I don't know, we have some examples. We talked a little earlier.
How about the what is it, tryptophan?
L-tryptophan.
Yeah, it's a big issue. I don't know if it is around the country, but in Minnesota, several new repeated have come back to the victims, and they're still in bad shape.
Let me let the gentleman at my right answer that question, Congressman. Mr. Shellen, would you? Are there problems we've had?
If I could just respond to your comment earlier about the food industry and give you some examples from our experience in the Detroit district. We have a breakfast food manufacturer which we have inspected 8 times in the last 4 years, and we've gone in there for a number of reasons. The one inspection, we went in to collect samples of raw materials, that is grain products, for nutrient analysis, and we asked them for information about their own nutrient analysis on these grains and the finished products that were made from them. They refused that information. We asked for information about nutrient stability in the finished product. They refused that information. We asked for product formulation information to see if the label declarations for the products that we were interested in were correct. They refused that information. We also, at that particular time, were following up on an allergic reaction to one of their products. They refused to allow us to look at their complaint files to see if there were other similar instances of allergic reactions to products.
They refused access to complaint files on health reactions?
Yes.
On L-tryptophan, you got a drug that caused real terrible problems. People are just immobilized.
Absolutely.
From their life has changed from an active one to terrible situation, and
devastating disease.
And there, inspection authority could have made a difference. At least the authority wasn't there.
I'm not sure about that one. I think.
Is anyone familiar with
I think
that?
We had some problems.
How about the unapproved use of prescription drugs? Is that an issue here?
I would need Congressman to think about that a little. I think that perhaps one could argue that there are people who are promoting the drug who are working for certain companies, and unless one had access to those records, it would be hard to document.
That's exactly it, promotion of unapproved use.
And who's promoting and what are the ties. If an independent person wants to go talk about a drug, that's okay.
You can't go to the marketing people and find out what their promotion.
I don't believe we can under the current statute. There is, Congressman, one point that I think is important to make, because the cases that you hear need to be put in perspective too. Because you hear of a difficult case in Detroit, you also have to understand that there are a lot of times, where we can affect change within the statute, and it's not fair to paint the picture entirely that the cases that are commenting on are 100% representative. I just don't want to leave that impression.
No, and that's the real problem, and why it's curious that more don't support a stronger enforcement effort, because I think legitimate industries get pulled down with the bad apples. They get cruelly painted, and the consumers take it out on all of them, and that's why I think that a strong and reasonable enforcement action, the FDA, helps industry as much as consumers.
Gentleman's time has expired. Did you want to respond?
If I may, Mr. Chairman, I just think there is one point that I'd like to, in response to that. Because I think we have seen, at least I have seen on my brief watch, Congressman, an industry that wants to be in compliance. I think that I have seen that dramatically with regard to the food industry. As soon as we said to the food industry that we want the rules followed and that we will assure a level playing field, that food industry is falling into line like we've never seen it before. And I think they deserve a lot of credit with regard to that. So you're right. They want a level playing field, and there's always some bad actors who bring down the industry, but the vast majority of the industry really want to be in compliance.
If you can inspect them and get in there early, you can prevent serious damage to reputations and goodwill and product lines of a bunch of good actors.
Absolutely.
Thank you, Mr. Chairman.
Thank you, Mr. Scorsese. Mr. Hastert.
Well, I thank the chairman. Certainly, we are walking on a fine line of trying to provide a very abundant and wholesome source of food for this country, as well as pharmaceuticals, and yet certainly protecting people's health and using that. The industry, basically, we talk about the difference between the criminal code and the civil code, and of course what you have the ability to use now is civil code, but isn't there another huge civil liability out there and just in the liability laws for most of these companies?
Absolutely.
And isn't there also criminal liability out there for most of these companies?
There's criminal sanctions. We certainly do have criminal authority also.
And just the ability of people to bring suits, both criminal suits and civil suits, other than yourselves against these industries. Is that not out there?
Let me let counsel comment on that.
Obviously, the Food and Drug Administration has civil as well as criminal authority, and most of the violations of our Act are already subject to criminal sanctions as well as civil sanctions. If your point was...
Well, my point is that the third party, I mean, anybody out there in any constituent, anybody as a citizen of this country or others can bring civil suit. And so these companies are certainly under a very, very tough liability constraint.
And not only that, Congressman, the biggest concern I'm sure these companies have, and not criminal, not civil penalties, but the credibility of their product.
Absolutely. Absolutely. It brings me to a situation that, you know, I went through a food industry in my district. There's quite a few food industries in it. And when I was just home last week, and happened to be a kind of a bakery concern, national, and they keep very, very intricate records on everything they do. Matter of fact, even the percentage of moisture that's in this product when it leaves the oven, and when it's packaged, and then when it's shipped, and on and on. And every other incidence that happens in this whole process, this baking process, where they're putting out absolutely millions of pieces of goods in a day. And, you know, they keep a very, very close record of everything they do. Every batch of flour, every batch of flavoring, every batch of, you know, and then what goes out. Now, according to the new legislation that's before us, your agency could swoop in and scoop up all this information. Is that not right?
We, under this legislation, would provide the ability to inspect records in the food area as we have in other areas.
So, and you can photograph, and you can bring in videotapes and every other type of information that's in the bill.
Congressman, I don't think we would be in favor of any extraordinary means. We're not looking to go in, swoop up anything.
My point is on this thing, I think that there needs to be a balance. And when I see industries out there, companies in the industry out there trying to take extraordinary means to keep a record, to understand, to learn, to share, and to keep quality, and then all of a sudden a piece of legislation would be passed that they would be jeopardized if they keep those records. Why would they keep records like that if they knew that they're going to be liable for them?
You know, I was in a similar position, and your concern is a real one, and I think that as we address this, we need to keep it in mind. Let me tell you, in my previous life, in running a hospital, I ran quality assurance of that hospital. It's absolutely critical to assure the quality of what we do. And we were developing much better programs and documenting much better. And there certainly, I had some concerns because the state or the JCH, it would come in and, you had a sense that they would use those records against you. But in the end, what I found, and then the question is there the incentive to develop those records if you're going to just use them against me? But I also found that sometimes having those records was our best defense. There is a fine line, and we need to find that.
Well, having those records, I think, is a good defense for the food industry too, especially if they're subject to libel suit. I mean, they can go back and check the records, and they know where they're at. And all the records almost should be a proprietary thing, and to have people swoop in and to look at, take all your records and your information that you do, and to help create a quality product, all of a sudden creates a disincentive to keep records at all. I mean, there's a great liability out there.
I think that we also have some experience in the other areas where we have records inspection and in the drug area. And I think we need to ask those industries what incentives
another question too, and I get a lot of give and take here, and you sometimes get caught in the muddle in between. You do have the ability to seize, right, now?
Absolutely.
And you've done that, right?
Absolutely. And
in the matter of fact, you've made somewhat of a reputation for yourself in the industry out there because you've been able to do that.
I think that's correct.
Well, what added ability to seize would you have that you don't have to? I mean, this legislation would say now that
I don't need any additional authority with regard to seizure, Congressman.
All right. One of my colleagues on the other side of the aisle brought up the situation about propriety, formulas, things like that. And I guess, the best kept secret or whatever in this country is, say, the Coca-Cola formula, something like that. What would prevent somebody from your agency coming in and finding that formula, a formula like that, for instance, that is a proprietary information, and then several years later being able to, once he has that information and not in your employ anymore, go out and exploit that?
You go to jail, sir.
Well, once that, even if that individual does that, once that secret's disclosed, it's not a secret anymore.
No question, you're correct, sir. But there are very severe criminal penalties for disclosure of trade secrets. But there is that risk.
People take those risks all the time. I'm just saying that I have a question.
I hope we create the deterrence so that people do not take those risks.
But those companies still are in jeopardy.
No question, there is a risk.
All right. I appreciate your certainly candidacy on this thing and your candid answers on this, and I certainly hope that we can work with the leadership and try to come through to some type of a semblance of a bill that we can all live with. Thank you very much.
Thank you, Mr.
I yield back.
Thank you, Mr. Hester. Mr. Wyden.
Thank you, Mr. Chairman. Dr. Kessler, Mr. Dingell's Subcommittee on Oversight and Investigations and this subcommittee over the years have had a great interest in the problem of policing food imports. And in 1987, I note that there were 1 million entries of food subject to FDA jurisdiction, and the FDA was able to physically test samples from slightly more than 2% of the entries, and they found a violation rate of 40%. My question is, given the large and steadily increasing volume of food imports and your limited resources of the FDA to sample them, isn't it clear that a significant volume of unsuitable foodstuffs are now getting by your inspectors and onto the table of the consumers in this country?
Congressman, I'm very concerned about the import problem. I think that there are a lot more needs to be done. I think it may be, if you had to rank the top priorities of the agency, the greatest problems confronting us, the import problem is very high on the list. If not the...
Be happy to yield.
I thank my good friend. I was a member of both this subcommittee and the Oversight Subcommittee. You have a situation where when you have sent people out to look at imports, and you're not able to do it very often with regard to foods, you find that the level of failure because they're filthy, adulterated, contaminated, contain improper pesticides, runs about as high as 40% in each instance. Is that not true?
That's correct, sir.
And you don't have enough people to keep at all of the ports. Isn't that so?
Absolutely. It is very labor intense.
And because of the way the law works, you have no authority to seize, condemn that food. You simply have to permit them to take and remove it from that point of entry, move it to and re-export it, and then they can bring it in to another port. Is that not so?
That certainly happens.
You have no way of preventing that kind of situation, and you have no people to deal with the issue at the other port.
It is certainly an issue that arises.
So you do need some ability to seize foods at the point of import.
Again, Congressman, let me let counsel talk about, because the import, we work very closely with Customs, and let counsel talk specifically about the seizure activities. It goes to the issue of bonds and detaining products. So again, I'm
transgressing on the time, my friend. I just wanted the summary. Counsel, I do appreciate that very much, but
we would be happy to supply that for the record.
It is also, you also have similar problems with regard to pharmaceuticals, do you not, at point of entry, in dealing with overaged, improperly marked counterfeits and pharmaceuticals of that type, do you not? Which do not comply with our law? Pardon?
We do have a problem with dealing with imports and pharmaceuticals, as Mr. Dingell is well aware from some of his past investigations, I believe.
You have the same problem with personnel to be at the points of entry there, do you not?
Very labor intense.
I've used too much of my friend's time. I thank him.
Well, I thank the Chairman. But on this point, Dr. Kessler, you do agree it's an important problem, but I do want your opinion. Isn't it correct that a significant volume of unsuitable foodstuffs get by your inspectors and get onto the tables of American consumers?
Yeah, Mr. Wyden, I don't know scientifically that that's the case. I can tell you that we're finding an unacceptably high violation rate. It's as if 40% of the people out there were speeding. That just is unacceptably high. I have to believe that some stuff is getting through. We're trying as hard as we can to target it, but that violation rate is way too high.
Now, you all had a management evaluation. The Division of Management Systems and Policy issued a report in March of 1990, and the report said, and I will quote here, "There can be little improvement in the efficiency of the present inspection program without additional resources and statutory authority." Do you agree with that conclusion that was arrived at by your Division of Management Systems?
That was part of our material weakness analysis. And I think it had three parts, Mr. Wyden. One, the issue of resources. Two, it was the issue of people forfeiting bonds, I believe. And three, of the ability, as Congressman Dingell said. And that report, I think, does really set the problem in the right perspective.
And let us establish with some certainty just how serious this lack of resources is. My understanding is that you all now, because of your shortage of resources, can only physically test samples from slightly more than 2% of the entries into this country.
I think our inspection rate is about 9%, and of that 9%, we actually test about 2%. Again, it's a targeted sample. We have the history. We try to use our resources the best way. There are certain places that ship. We know that they're going to have a higher violation rate, and that's where we have to put our resources.
Be happy to.
In Nogales, FDA has 1/2 of one person checking, that's 1/2 of a man day or man year, looking at the safety of food imports, but Department of Agriculture's got 70 measuring the size of tomatoes. How does that strike you as a comparison of your abilities versus FDA versus Department of Agriculture?
Congressman, I think there's no question. I'm concerned about our ability to monitor imports. This is an area that we are not doing enough.
I thank you.
I thank the gentleman. Having established the small number of samples that are actually physically tested, and we appreciate your agreement with that management evaluation of 1990 indicating that additional resources and statutory authority are needed, the Oversight Subcommittee, with very helpful technical drafting assistance from your agency, prepared the language contained in Section 8 of H.R. 2597, which largely implements the recommendations in the FDA's own study with respect to resources and statutory authority. Do you support Section 8 of H.R. 2597, Doctor?
Congressman, I'm not prepared to support any specific language today. I think that it's very important that we work together expeditiously to solve this import problem.
Well, let me ask you, are there any parts of Section 8 which I really do feel compelled to inquire about, because it goes right to the heart of the enforcement capability? Are there any parts of Section 8 which you do not support at this time, Doctor?
Again, Congressman, I think that the import, as you pointed out, that there's a whole set of issues on that import problem, and what we're trying to analyze is where these fit in. We have to do a much better job with our MIS systems. They're very poor. We are putting a lot of money into those. We need to have a concerted effort and concerted program on all these, and I certainly believe that these kind of provisions need to be, we need to work together to get this program up and running.
Let us see if we can look at some of the parts of Section 8 and at least get your reaction on those. The Subcommittee on Oversight found that even when the FDA's limited testing discovered adulterated or otherwise unacceptable goods, in many cases the importers had not maintained custody of those goods and they had already been sold into commerce. Now, Section 8 has provisions specifically designed to stop this very serious abuse by increasing the bond that the importer has to post, and in extreme cases denying the importer the privilege of taking custody of the goods from customs before getting the notification from the FDA. Now, this, of course, is designed to eliminate the economic incentive for importers to prematurely release the goods. Do you support this provision of the legislation?
I certainly support solving this problem of people forfeiting bonds and viewing the cost of doing business at the risk of jeopardizing the public health. I would like my colleagues from Customs to be here. The question is, what is the right deterrent? The right deterrent currently does not exist. People are forfeiting bonds, and we're not handling those products appropriately.
The bonds are too low. Isn't that the case?
Absolutely. I think that there is no question that the current deterrents are not enough.
Thank you, Mr. Wyden. Mr. Richardson?
Thank you, Mr. Chairman. I have two questions, one on interstate commerce and the other on the park doctrine. Dr. Kessler, Section 9 of the legislation would define, quote, interstate commerce in the Act to include products that affect interstate commerce. I understand that industry officials admit that they rarely contest FDA cases on the grounds that the goods at issue did not move in interstate commerce. Now, would such a provision save the agency significant resources?
There's no question that I don't think we've ever lost an interstate commerce case. But I think Mr. Hoding and gentlemen could tell you the efforts that have been expanded to documenting it. I think we've analyzed the problem. I think we've come up with something like it's 25 FTEs, 30 FTEs, approximately a year that it costs us in documenting. Again, we're talking about efficiency. We can get the job done, but it's not very efficient.
What impact would this change have on the types of cases that the FDA brings?
I don't believe it would have any changes in the types of cases, Congressman. I think we're talking about the efficiency of resources.
What about what impact would this change have on the agency's jurisdiction?
I don't believe it would change the agency jurisdiction whatsoever.
Would it allow the agency to prosecute cases that are not within the agency's current jurisdiction under present law?
I do not believe so.
Now, on the park doctrine, several of the witnesses who will testify in the last panel argue that the FDA should not be permitted to retain the park doctrine, which provide for strict criminal liability of corporations and high-level officials. What impact does a strict criminal liability doctrine have on your ability at the FDA to enforce the Federal Food, Drug, and Cosmetic Act and on public health in general?
I think the agency's longstanding position on that, Congressman, is that the park doctrine serves as a deterrent, that it requires people to set up systems, and that's where its usefulness lies. And when company officials set up those systems to assure compliance with the Act, that's what we want to achieve.
My last question, Section 7 on the inspection authority would also give agency employees additional authority to carry firearms and to serve warrants. Agency inspectors already have this authority in connection with investigations into counterfeit drugs. Are there any instances where agency employees are in jeopardy because they're doing investigations in other areas but do not have the authority to carry firearms and serve warrants?
I think we've gotten into some pretty hairy situations. We just did the GHB investigation. Some of the things we get into is
prescription drug diversion.
Absolutely, and again, we're taking very seriously. We are bringing on board Mr. Hoding, and his group is working very hard in getting our group of criminal investigative and our criminal investigative unit up. So they need the tools to be able to do their job.
Anabolic steroids.
Absolutely.
Isn't that a crisis in our healthcare system now? Not just because Lyle Alcedo has an issue that he's raised, but what are we doing about containing that spread through professional and amateur sports?
As you know, Congressman, the anabolic steroids were shifted, last year to the DEA, but there's still a problem with some of the synthetic things that look like anabolic steroids. That's still within FDA's jurisdiction, and I think we have just we're cracking down. We cracked down on GHB. We let the world know about it. We are prosecuting individuals. Again, we haven't solved it by any means. But I think now that DEA has the anabolic steroids and that we have the synthetics, I think we have more resources available.
Should there be mandatory testing of professional and amateur athletes?
Congressman, there's a lot on my plate. That question goes. I don't think I have jurisdiction.
I'll check with Chairman Dingell on that.
He doesn't, but we do.
We do, yeah.
Have you completed your question? Thank you, Mr. Richardson. Members will now, if they wish to, be permitted a second round of questions, certainly not mandatory, but I do want to recognize those who do want to ask another round of questions. Mr. Dingell, you indicated earlier you might have other questions. I want to recognize you at this time.
Thank you, Mr. Chairman. I thank you very much. Doctor, we were talking about recalls. Now, it takes weeks or months to effectuate a recall. And in fact, if such recall is finally effectuated, it takes a substantial amount of time. These events are not unique to PBI, which you and I were discussing earlier, are they?
That's correct.
As a matter of fact, you've had similar problems, just for example, in getting Duramed and Zenith to recall conjugated estrogen products from the market. Is that not so?
Yes, sir.
And there have been a lot of other cases, too. Now, in fact, in the case of the conjugated estrogens produced by Duramed and Zenith, not only were the products failing stability or potency tests, but the agency had determined months before that the Class B conjugated estrogen should not be allowed on the market, even if produced in accordance with ANDAs. Is that not correct?
That's correct, sir.
So the subcommittee has numerous cases, this is a subcommittee on oversight investigation, has numerous cases in its files where seizures of generic drugs were recommended in the field, many of which were disapproved at headquarters. These seizure recommendations were often caused by lack of agreement by a firm to voluntarily recall. Is that not correct?
Yes, sir.
So you have to, now, seizure is a very interesting practice. You have to start to seize the entire flow of commodities in commerce. You have to start a seizure case in each United States district court district. Is that not so?
Yes, sir.
So that means to effectively clear substances from the market, if you can't get a voluntary recall, you have to start, I don't know how many U.S. court districts there are, but there are a lot of them, a seizure process in each and every one of those.
Yes, sir.
Enormously expensive and time-consuming, is it not?
Yes.
And it tends to frustrate good enforcement of the law and encouragement of voluntary cooperation with you with regard to recalls, does it not?
Absolutely.
Now, would you supply for the record, well, I'm sorry, if you had the recall authority contained in H.R. 2597, would the agency have been able to assure that the defective products and those which were produced under licenses which were obtained through fraud and false statements could be removed from the market more expeditiously?
Mr. Congressman, let me do the analysis then and provide that answer, if I may, for you.
I believe it's yes, though, isn't it? Would you supply for the record a list of all generic drug firms that have resisted either formal or informal requests for recall from FDA, either at the district or headquarters level, from May 1989 forward?
We would be happy to do so.
Now, Doctor, can you provide us with any estimates of the benefits in the proposed recall authority? Now, these can be measured either in terms of reduction in the cost of the agency and the Justice Department, or abatement in the needs to procure seizures that would not otherwise be necessary, or your best estimate of the amount of time and money that could be saved, or the additional product that would be covered by the agency's ability to have recalls and orders for recalls rather than to be forced into protracted negotiations and ultimately into legal action.
Let me undertake that analysis.
I think that would be very, very helpful to us, Doctor. Now, Doctor, Mr. Wyden was inquiring of some concerns of mine. The provisions referred to in Section 8 of the bill are aimed at eliminating economic incentive for importers to prematurely release their goods. Isn't that a fact?
That's correct.
Now, the legislation requires importers whose goods have been rejected and will be re-exported to mark such goods refused entry to the United States. Is that not so?
I believe that it depends. There's a split there on whether there's a health hazard or not. Perhaps Ms. Cobb can.
Yes. Wouldn't that, however, effectively bar them from being re-imported? Customs people could just look at them and say, well, these things have been thrown out of the United States because they do not comply with food and drug regulations.
Well, I would hope that label would continue to be attached. I don't know that I assume that will get to the heart of the issue. I just don't know. They have to be marked under the bill, and I hope unscrupulous people can get away with.
Wouldn't that be helpful to you?
I think that if we knew that already that they were violative, it would certainly put our field force on alert.
Now, the bill also requires in this section that articles which present a significant risk to human or animal health will be destroyed under the supervision of the Customs Service. Wouldn't this help to protect the health of the American consumer?
I certainly don't want violative products people being exposed to that, and those products should not get to the public.
Now, there are large numbers of these. There are large numbers of instances where these goods have not only been re-imported into the United States, but also where they've been sent to third world countries as well. Isn't that a fact?
Absolutely.
Now, anything else? Anything else? Doctor, thank you very much, and I thank your associates. Mr. Chairman, I thank you for your courtesy.
Thank you, Mr. Dingell. Mr. Wyden, you won the second round.
Yeah, thank you, Mr. Chairman. Just a couple of questions, Doctor, about the cosmetics industry. Using the existing authority that the FDA has, can the FDA accurately represent to the American public that cosmetic products are safe?
No, I'm not the. I don't believe in saying that everything is just fine. Everything is always safe. Everything is relative. I think that people can take comfort that our cosmetic industry is as safe as they come. But everything is relative. There's always the opportunity to do a better job.
Let me tell you what one of your FDA cosmetic staffers told the New York Times last year, and I'd like to know if you agree with it. Your expert said when a consumer asks, is this product safe, your expert said, I cannot say. And this was an individual with 45 years of experience, the last 17 at the FDA. He said, and I quote, we don't have the data on toxicological testing, quality controls, specifications, goes on. Do you disagree with that statement of a chemist at your agency for 17 years who, when asked by a consumer about cosmetics, is that product safe, and he said, I cannot tell you. Do you disagree with that statement?
Congressman, I think that that statement needs to be put in the context of everything that's done with regard to cosmetics. There is no question that the regulatory requirements with regard to cosmetics are not the same regulatory requirements as to other products. That doesn't mean that those kind of analyses are not done by companies. It means that there's a different regulatory framework.
Well, let me ask you one additional question, and Mr. Chairman, I thank you for the time. 21 CFR 740.10 requires labeling of cosmetic products for which adequate substantiation of safety has not been obtained prior to marketing. Now, my understanding is that your agency doesn't have the ability, given your resources and your existing authority, to get companies to adequately substantiate the safety of their cosmetics prior to marketing. Is that correct?
Again, Congressman, to be honest with you, I just have not looked at that issue. I just don't know how to answer that question. Perhaps there are other people. There's no one from CIFSAN, from cosmetics, but I would be happy to supply that answer.
Well, I would like that, because I think that regulation is a hollow promise, to the American people. Your own experts, people with literally decades of expertise at your agency, are now saying that an $18 billion industry, which has been allowed to put coal tar hair dye into products, nitrosamines, and numerous chemicals that have been linked to cosmetics, they're saying they cannot represent these products are safe. And I would hope that with the additional resources and the additional authority that the Congress looks to want to give the FDA, that you all would get serious about this industry, which any time you walk into a store in this country is virtually asserting that they can rebuild people with new cells and all kinds of other very bold claims. And I think that your agency has got to move into this area and quickly.
Ms. Porter.
Mr. Wyden, I think part of what you may be getting at is that there is not a product pre-market approval system for cosmetics. As Dr. Kessler pointed out, the authorities basically for regulating cosmetics are whether they are adulterated or misbranded. This legislation, as I understand it, would give us additional access to records maintained by cosmetic manufacturers to verify certain safety issues. But at least unless I'm missing something, there's no pre-market approval system in this legislation for cosmetics.
Well, there are 2 points. Neither I nor anyone else is advocating pre-market approval. I'm saying that I think it's a joke that there's a regulation on the books that's supposed to have companies substantiate safety. I think it is a hollow promise to people. Your own authorities are telling you when consumers ask, is this product safe, you can't answer. And I would hope, Dr. Kessler, we get serious about getting into this area. I mean, the days when you would take one of these products and you put it on your skin and it says freshen up, those days are over. These are products that are making major health-based claims, and we're going to need some changes.
Mr. Chairman, can I just respond to
please.
That question? There's no question I think we can do a better job in cosmetics. But in the end, it's going to come down to an issue of priorities, and I think we're going to have to collectively make that decision. Because we talked, some members here talked about the enforcement activities and the increased resources that I feel very strongly about to that field. We talked about the drug review process a little and the incredible desire to get products out there quicker, and the tremendous amount of resources that will consume. We have to recognize that unfortunately within the constraints that are available to the agency, there are limits, and we have to set priorities. I would like to do more on cosmetics, and I'm willing to work with you, Congressman, but there are a limit, and we cannot do everything, and people have to recognize that.
Thank you, Mr. Wyden. Your time has expired. Dr. Kessler, you indicated that the four gentlemen that have accompanied you represent 100 years of experience working.
Perhaps more, sir.
Perhaps more at the FDA, in the field, in the area of enforcement. And let me address this question to the four of them. You've had you don't speak for the administration, and I'm not asking you to speak for the administration, but in your professional judgment, and I'm sure in the preparation for this hearing you've had a chance to read the legislation. Let me ask you, just be very brief about it, do you think it would be helpful for you to have recall authority as spelled out in this, this legislation?
Thank you, Mr. Chairman. The courts have issued divided opinions on whether or not FDA has recall authority. The proposed legislation would resolve that matter and would give the courts authority to order recalls. The proposed legislation would also make it very clear that the Commissioner would have the authority to ask a firm to recall a product if the product is involved with fraud or a product presents a significant danger to health. Certainly this kind of authority would help clarify our current situation.
In other words, you're the chief enforcement person at FDA. You think the enforcement of the recall authority that we would give to FDA would be helpful. Is your answer yes?
Yes, sir.
Does anybody disagree of the other three?
Certainly not.
No, sir. The no is you don't disagree. In other words, you think this authority would. Well, let's go on to the embargo authority for all products. You have it for some products, but not others. Do you think it would be helpful to you in carrying out your work if you had that authority?
Certainly, embargo authority would give the FDA the authority to freeze and stop movement of articles which are adulterated or misbranded.
So you think that's a helpful authority?
Yes, sir.
Anybody disagree among the four of you?
No, we agree.
Subpoena authority for all products, as we spell out in the bill. Is this going to be worthwhile for you? And if you run into problems where this authority would have been helpful,
Mr. Chairman, I think if I may, I think it's important that the agency speak with one voice. And certainly I perfectly allow other people to speak with their professional judgments, but I think it is awkward. And if I could request, we're working hard, and if we can do that, I would appreciate it.
Well, Dr. Kessler, you're a political appointee, and you're representing the administration here today, and the administration doesn't have an opinion, and that opinion will be formulated after discussions, FDA to HHS to the White House. I don't know who else involved. Maybe the Competitiveness Council will be brought in on this one. But that will determine the administration's official position. What I thought it would be helpful for us to know is, for the people who are working in the field, whether they think these authorities are important to them.
And all I ask, Mr. Chairman, is we're a large organization. And we want to work with you, and we want to be helpful and provide the kind of information necessary to analyze and move forward. But I strongly believe that if we're going to tackle these problems, we really have to do it the right way. And it would be helpful if we can have a little more time, put our thoughts together, work with all people, and speak with one voice. I think that would be much more useful than having individual people on the record.
Okay. Well, Dr. Kessler, what I hear you saying is that you've got discussions yet to take place within the administration. I would hope that the views of the enforcement people will be made available, not just to you, but to others in the administration. And I accept what you're saying to us in good spirit, because what we want is a law that we can all support, and that means working with you and working with the people and the others in the administration as well to make sure that the FDA has the tools it needs to protect the public health. So I will rather than go through this line of questioning, leave it to further discussions for all of us to work together on this legislation.
I appreciate that, Mr. Chairman.
Do any of the other members wish opportunity for a second round of questions?
I just have one question, and I will also ask the question to Dr. Kessler, and it should elicit a very quick answer. I am looking at the table of contents of the legislation, specifically Section 3, Section 4, 6, and 7, just the title of it. Is it not correct, Dr. Kessler, that in the following sections you already have, I'm looking at page 2 of the bill, you already have, perhaps in a limited fashion, correct, Section 3, Administrative Recall Authority. You have in limited that and Section 4, Embargo Authority. Just for the record.
We have recall for infant formula, for example.
And embargo in medical devices.
Yes.
And embargo authority. Yes, Section 6, you have civil money penalties authority, correct?
Right.
Section 7, you can already deal with inspections and records.
In certain areas, sir.
Right. So really, out of the 11 titles, you already can deal with 4 of them, correct?
In certain areas.
In certain areas.
Gentlemen, yield. FDA has authority in some of the areas over which they have jurisdiction to do each of these things. In other areas, they don't. What the legislation would do would be to let them have this authority wherever the case may come up, whether it's a food or a drug or a cosmetic or whatever. And there's no authority being bestowed upon them in this legislation that other regulatory agencies don't already have. We're not talking about something that's brand new and shockingly shocking authorities that have never been granted to government agencies. We're just saying the FDA ought to have the same kind of authorities that other agencies have to do their job, and the FDA ought to have the same authorities in the area of drugs that they have in medical devices and in other areas across the board.
Mr. Chairman, that was my only question.
Thank you. Anything further from members of the committee? We thank all of you for your participation in this hearing, and we do look forward to working with you in order to get legislation adopted. Thank you for being with us.
Thank you.
We're going to break now and return here at 2 o'clock to reconvene the hearing. Meeting of the subcommittee will come back to order. For our our first panel, second witnesses today, I'd like to recognize John Rother, Director of Legislation and Public Policy Division, American Association of Retired Persons, and Dr. Sidney M. Wolf, Director, Public Citizen Health Research Group. We're pleased to welcome the two of you to our subcommittee hearing today. Your prepared statements will be in the record in full. We'd like to ask, if you would, to limit the oral presentation to no more than 5 minutes. Mr. Rother, why don't we start with you?
Good afternoon, Mr. Chairman. It's a pleasure to be here. I just want to make a few key points. Our testimony is fully in support of this legislation. I am here because the safety, the integrity of food, drugs, cosmetics is a vital issue for our membership. Recent scandals, including but not limited to the generic drug problem, have shaken that confidence. I believe that we have a stake, and every household in America has a stake, in not only the credibility of this industry, but also the credibility of government as it tries to fulfill its promise to protect the safety and efficacy of these kinds of products. We certainly expect the FDA to be the leader in consumer protection, and it is a consumer protection agency. I was privileged to serve as a member of the Edwards Commission panel for the past year, and I can share with you the fact that the FDA needs help in many areas, not just the enforcement area. It certainly needs help with additional enforcement tools, but it also needs resources. And while additional enforcement is sufficient, it's not sufficient, but it's necessary. And so we certainly see this as an important step forward. I would like to call your attention to the language that the Commission used in its report on enforcement. And the conclusion of this Commission, which represented a very broad range of participants, leaders in the industry, in the drug industry, food industry, as well as consumers. Congress should review the FDA's current mixed bag of enforcement tools and enact legislation to streamline, expand, and modernize them. The agency should be armed with the same tools for all products that it regulates. And I think that's really what this legislation tries to do. That was a unanimous recommendation, and included in that unanimous recommendation was the support of the industries who are now qualifying their willingness to abide by that kind of policy. I'll just make a very few summary points here. I think the basic principles are that the FDA should have the same complement of flexible enforcement tools that most other agencies already have. I clearly see this legislation as incorporating that. Secondly, those tools should be available uniformly across the entire FDA jurisdiction. I think the imaginary abuses, some of which were referred to this morning, are not likely to happen under any kind of competent leadership. We have other means for redress. When it comes to protecting the public health, the integrity of our food and drugs, we should not err on the side of timidity when it comes to giving regulatory agency the power to protect the public health. Another point is that these tools would make for a more responsive and more efficient FDA. I think Commissioner Kessler was exactly right when he said the FDA could do its job today, but it could do it only under a very complex, complicated, and often very inefficient set of procedures. These tools would allow the FDA to make more efficient use of its resources and to respond more quickly and more effectively to potential problems. Certainly that would improve consumer confidence, but it would also improve the reputation of the industries being regulated. To the extent we do have and will always have some bad apples, it seems to me that it's to everyone's interest to get those problems dealt with quickly before we get into another generic drug problem or a truly massive public health problem. Finally, Mr. Chairman, this is not just a incidental bill. This bill is crucial to the continued ability of the FDA to keep up with the ever greater demands that it faces, not only in the food area but across its jurisdiction. We will have continuing scandals. I mean, that's inevitable with this many people, this many commercial interests. But when those scandals occur next, I think it's going to be awfully important to members of this committee, to my organization, to say that we did everything we could to minimize that threat. And I would say to those who are opposing this kind of measure that they may be held partly responsible for any suffering that may come from FDA's inability to be as vigorous and as strong and as responsive as its charter requires it to be. So with that, Mr. Chairman, I'd be happy to take any questions.
Thank you very much. Let's hear from Dr. Wolf first, and then we'll have questions for both of you.
Listening this morning to the discussion, some of the things that got repeated by people on both sides of the aisle and on both sides of the witness stand were things like confidence. Everyone agreed that there's a problem of confidence in the FDA because of a lot of problems that have occurred. Also, criminal activity. There seemed to be a tendency to mix up people who are involved with cocaine who, unlike the drug, device, and food manufacturers, do not have a license to engage in interstate commerce. The fact that there's a different standard, at least I'm not aware, unless something has happened to prove interstate commerce and cocaine, that the privilege or the right to sell at a profit as it should be applies to these other kinds of people. I'm not diminishing the problems of drugs on the streets, but certainly it is reasonable when the stake is not a few people dying from cocaine, but hundreds of millions of people, tens of millions of people exposed to one product that might be contaminated. The stakes are higher, and there's a need to have the kinds of additional enforcement tools that you mentioned. The budget was another issue mentioned, and you heard how time-consuming and labor-intensive it is from the inspectors in the field not to have some of these tools. And I would argue that a number of the items in your list of additional enforcement tools would reduce the amount of expenditure on the part of the FDA, would not need additional expenditure. They'd be able to quickly and promptly get the kind of information that they now have to beat around the bush, not only at their own expense, but the expense of the public that is exposed to these products in the interim. I agree with all of the 10 pieces that you've added to the enforcement armamentarium of the FDA, but we have 5 additional ones. These come after discussions with people in the FDA. 4 of them concerning drugs were recommended by an FDA panel in 1977 and by and large agreed upon by the FDA at that time in response to the panel. I'll just go briefly through them to use up the rest of my 5 minutes. 1, add explicit statutory authority to require FDA to promulgate mandatory good manufacturing practice regulations for foods and cosmetic. The drug and device laws have this authority, and as a result there are regulations on the books for drugs and devices requiring good manufacturing practices on the part of a company. No such explicit authority is there for foods. There are only guidelines for good manufacturing practices, and at the level of the inspector, and I'm sure that you would have heard that if there had been a chance to discuss it this morning, it means that for drugs, FDA can find a drug company in violation of GMP laws and regulations if it can show that the company's manufacturing practices could result in adulterated drugs, even if evidence of adulteration has not actually been found. This is a crucial preventive approach, and it's missing in the case of food and cosmetic inspection. Here, it is much more difficult in the absence of a finding of adulteration to go after these companies. Examples of recent adulterated food disasters which could have been prevented by having GMP regulations include a number of instances of contamination of dairy products with Listeria monocytogenes. The most notable instance involves soft cheese contaminated with this dangerous bacteria because of poor manufacturing practices, which resulted in many deaths and an even larger number of serious injuries. They had to wait until people died rather than going into the plant and saying, even without a finding of adulteration, you've got practices that just aren't any good. There aren't regulations for that. This also fits in with your Section 7 in H.R. 2597, which gives stronger inspection authority. Without good manufacturing practices, the inspection authority would not find really the kinds of practice or procedural violations that they can now find for drugs and devices. Secondly, and it's indirectly an enforcement issue, require public disclosure of safety and efficacy data on drugs, devices, and diagnostics at appropriate stages of FDA review. The 1977 review panel on the FDA said that Congress should immediately amend the law to provide that safety and effectiveness data do not constitute trade secrets for purposes of the federal prohibition against release of confidential and privileged information. The panel also said that the present policy places FDA in the untenable position of having to justify its decisions without being able to refer publicly to the data on which the decisions are based. The other 3 issues involve, 1, the ability explicit to restrict distribution of drugs, either upon finding that they are being used for unapproved purposes, or if the danger of the use as it is going constitutes an unwarranted safety hazard. And finally, the 5th issue is to give independent litigating authority to FDA at both the trial and appellate divisions. This was also dealt with by the review panel, and the review panel felt that in many cases products were staying on the market much longer because of the often tortuous way in which the FDA had to go to the Justice Department for help.
Thank you very much, Dr.
Glad
Wu.
to answer any questions along with John.
Mr. Rother, in discussing this legislation, representatives of regulated industries have argued that FDA should not be given authority to examine records because they contain trade secrets. FDA now deals with many sensitive trade secret areas, especially in the approval of drugs and devices. In your experience with the FDA Edwards Commission and with the AARP, are you aware of any divulgence of industry trade secrets, and has this been a problem?
Mr. Chairman, I've been working in this field for about 15 years now, and I have never dealt with any employee of the FDA or anyone in the field who has improperly even hinted at disclosure of trade secrets. I think this is something that people take very seriously. There are very serious sanctions for it, and I believe that although Commissioner Kessler may have been right to say that there is a minimal risk involved, certainly the risk to the public health from not having that information outweighs any minimal risk of unwarranted disclosure.
You've identified one of the problems at FDA as lack of resources. Let me ask you about the ways of streamlining resource needs. As you no doubt know, in any enforcement action now, FDA is required to prove that a product has been in interstate commerce. While this is rarely challenged by the regulated industry, it's a matter of proof that is time-consuming, labor-intensive, and filled with paperwork for FDA. This legislation would amend that standard to be a product that affects interstate commerce, a standard that has clear precedent in other areas of the law and would lighten the resource demands on each enforcement proceeding. In your experience with the FDA, Edwards Commission, and with AARP, does this seem an appropriate way of redirecting FDA's limited resources?
Well, the Edwards Commission was alarmed to find the enforcement of the current FDA laws hampered by so many seemingly unnecessary procedural steps. We had testimony in front of us from field staff in the Commission who detailed sometimes as many as 15 different steps that had to be undertaken to get a subpoena, for example, and a very unwieldy, very slow, very cumbersome process, clearly not an efficient use of FDA resources. So in that respect, I think this is prudent use of limited resources, as well as, frankly, a non-controversial area. I think most of us think of our national economy as one economy and not 50 separate state economies.
Dr. Wolf, do you agree this would be a more efficient use of resources if we had this definition of interstate commerce?
Yeah, absolutely. I mean, I think that what you heard this morning on this and a number of other issues were these barriers that wound up taking an enormous amount of time and people hours on a case that could have been culminated much more quickly. I think I agree with Mr. Rother fully that the streamlining part and the part that is expanding the authority are really in many ways one and the same, because by expanding the authority to more quickly get records or subpoena or whatever, you really are streamlining it, and I think the per case expenditure of FDA people would go down, not up.
Dr. Wolf, witnesses on the next panel have submitted testimony arguing that the current FDA enforcement powers are sufficient, that there are no problems in enforcement. You've argued for even stronger measures than are in the bill before us. Let me ask you in general, does FDA have the tools needed to enforce the consumer protection provisions of the law, and is current enforcement authority adequate?
It has been our view that it isn't adequate. We were disappointed when 13 or 14 years ago, when the administration itself proposed legislation that incorporated a certain number of the things that you have, that it went down again because the industry doesn't like to be regulated. You heard from the inspectors this morning how point by point the addition of the ability to get records, the ability to subpoena for more information, the ability to make recall a mandatory as opposed to a haphazard kind of process would all improve the protection of the public health. The people you heard from this morning, aside from their 100 years of experience, are people who have dedicated their lives to protecting the public. That's what, I mean, aside from, they are not on the side of the FDA that is looking at new drug applications or new device applications.
Let me ask you this. I would like you to supply examples for the record of instances in which enforcement authorities are too limited for public safety, and then I want to ask you one question before my time expires. One of the witnesses to follow you has argued that FDA enforcement is more vigorous than ever, and he says what he calls informal regulatory actions have more than adequately replaced formal actions of the past. I have two questions for you. First, do you agree that FDA enforcement is more vigorous than ever? And second, and more important, is FDA enforcement adequate now?
Well, the first question is it's more vigorous than ever during the last 10 years, but that is a sort of pitiful basis of comparison. It reached all-time lows in many respects over the last 4 or 5 years. Yes, it's gotten better. It is nowhere near good enough, and I think really more, I mean, aside from enforcing the existing laws, which is what really we've been seeing so far, just in the process of getting up to a higher peak on that, we need these extra tools. I mean, these are not new laws for approving drugs. As you pointed out at the beginning of the hearing, this is the first significant set of enforcement additions in half of a century, practically. And if we are in the latter part of this century, if we're going to move safely into the next century with all of the more complicated distribution systems and everything, I think we need more authority. What we have now isn't enough. To say that it's better than it was is really a tragic kind of comparison to be making.
And Mr. Chairman, if I could add to that, public demand for greater protection and greater information in this area is multiplying. And to the extent that the federal government cannot respond, we are seeing, and we in fact are working with many states to increase their efforts here and their oversight and their enforcement tools. And I think really we have a choice. We can either do it right at the federal level and have a uniform system across the country, or if the federal government is not going to be serious about this, then we certainly we're going to be working very vigorously at the state level to put in those tools and those protections that we are not seeing here. Because one way or another, consumer concern about this is going to be expressed.
Thank you very much. Dr. Rowland?
You pointed out we are looking at enforcement authorities and not the approval process here, but let me ask you this question. And I understand that the approval process in this country is considerably longer than it is in other countries, maybe 7, 8 years here, whereas it's a shorter period of time in other countries. Do you think that increased enforcement authority for FDA would in any way impair the approval process even further in this country? For example, if there was authority for inspection of container manufacturers or commercial testing laboratories or collecting samples, many different areas that you could look into in enforcement, do you have any concern that that might in some way adversely affect the approval process that we now have in place?
I don't. I think that the approval process that we have in place, which does take longer, as you point out, Dr. Rowland, than in other countries, has spared this country of a number of drugs that came on the market in Britain and other countries and then had to be banned because they were too dangerous. We were spared of those drugs. Most of the drugs, 80 to 90% each year that are approved, are not important advances over existing drugs. So that if those drugs, for example, take longer, I don't think there's really anything lost from the patient's perspective. The ones that we're all concerned with are the tiny number of drugs that really are life-saving and can make a big difference because there's no other therapy, because they're a big improvement. And I think that we have seen with AZT, for example, a sort of record fast approval once data was submitted. And you heard Dr. Kessler this morning talk about processes that are being set into motion to increase that at the very time that there are more enforcement actions. I don't think that the addition of these other enforcement tools would in any way impair. I mean, one might argue that it might speed up the approval process because the FDA would have much better access to the kind of records that could allay some of the concerns that they now have about what is going on in these manufacturing plants.
Thank you. Thank you.
Thank you very much, Dr. Rowland. And gentlemen, we appreciate your testimony. For our last panel, I'd like to call forward Edward Dunkelberger from Covington and Burling, representing the National Food Processors Association, Peter Hutt, Covington and Burling, representing the Grocery Manufacturers Association, Ted R. Mannon, Executive Vice President, Health Industry Manufacturers Association, who will be accompanied by G. Thomas Long, Director of Government Affairs, and Gerald Mossinghoff, President of the Pharmaceutical Manufacturers Association. We're pleased to welcome you to our hearing today. Your prepared statements are going to be in the record in full. What we'd like to ask each of you to do is to limit your oral presentation to no more than 5 minutes. And Mr. Dunkelberger, why don't we start with you?
Thank you very much, Mr. Chairman. I'm Edward Dunkelberger, General Counsel of the National Food Processors Association. I will highlight my statement as just going through it, hitting some of the high spots, if I may. We certainly appreciate the opportunity to testify on H.R. 2597. For the past 85 years, the Association and its food industry members have consistently supported legislative, appropriation, and regulatory measures to strengthen the ability of the FDA to carry out its administrative and enforcement responsibilities when such measures have been found to be necessary in order to address identified needs and shortcomings in existing laws and regulations. We are aware of no evidence, however, that the FDA's current inspection and enforcement powers are inadequate or that the agency has been unable to carry out its statutory responsibilities because of shortcomings in its inspection and enforcement authority. Indeed, it is particularly ironic that legislation to enhance FDA's enforcement authority is being put forward at a time when the new FDA commissioner has demonstrated so forcibly that his agency is in no sense handicapped in carrying out its statutory obligations or in securing food industry compliance with the FDA's views of the labeling requirements of the Act. I can assure you that food companies are extremely attentive to the enforcement policies of the agencies. Let me review very briefly the enforcement authority it does now have, and I think other witnesses may cover that. First and foremost is absolute strict criminal liability. Several references were made today to criminal liability and FDA's authority in that area and that of other agencies. Except for USDA's Meat and Poultry Inspection Acts, which really copied the FDA Act, all other statutory authority that's referred to today, as far as I am aware, is enforced through a standard of willfulness, intent, or negligence, not through strict criminal liability. In most other federal crimes in such areas, antitrust, narcotics, pornography, sexual abuse of children, many, many others, the standard is willfulness, negligence, or intent, not whether the act was actually committed. The agency also can seize products in the field. There was considerable discussion of that today. We've seen already an example of one seizure of one company's products allegedly mislabeled resulted in a wholesale turnaround of food industry labeling practices. Frankly, I'm at a loss to understand why the FDA could testify today that there were out there companies refusing to make recalls and apparently asserting that their product was out in interstate commerce and trying to persuade the company to make one kind of recall over another when, as far as I could see, they'd make a single seizure and contest the issue, multiple seizures if necessary. They could have sought an injunction from a federal district court to restrain violations of the Act. None of those authorities were exercised in this case. As far as I can see, there was more than adequate authority to be responsive to any situation where the FDA identifies violative products out in the marketplace. The common feature of all of FDA's existing enforcement authority, criminal authority, seizure, and injunction, is that no sanctions may be ultimately imposed upon private citizens until a federal district judge has concluded that a violation occurred. This, as far as we are concerned, is the principal distinction between the way the FDA now works and the way it is proposed that it would work under this statute. In every case, the legislation would attempt to take out judicial opportunity for review and approval of FDA action before the event occurs. There would be an embargo solely on the basis of any FDA employee saying, hold it for 30 days and that's it. No chance to second-guess that authority, even within the agency. A recall. The agency would order the recall, and failure to observe the recall would be a criminal violation. In other words, the recall is ordered by the FDA official, and then the statute as drafted says that's a criminal violation not to observe the recall. As far as I can see, the issue is not then in that criminal violation whether the recall was even justified. The same thing with civil penalties. The very agency that charges the violation would be the agency who would then hear whether a violation occurred and decide whether to impose $250,000 per violation penalties. I cannot sit here in good conscience and seriously entertain the idea that this bill was drafted as an effort merely to mirror the authority that's granted to other agencies. No federal agency can impose $250,000 fines on individuals. Indeed, in view of the United States v. Halper case, as far as I can see, that's subject to very serious constitutional objection. It does not look to us like an effort merely to improve FDA's, to make it easier for FDA to enforce the Act. It looks to us to be an extreme measure to impose punitive penalties on industry representatives.
Thank you. The rest of that statement will be in the record.
Thank you very much.
Mr. Hutt, would you speak into one of the microphones?
Thank you, Mr. Chairman. I'm Peter Barton Hutt, a partner in the Washington, D.C. law firm of Covington & Burling, appearing today on behalf of the Grocery Manufacturers of America. GMA is a national trade association representing more than 130 companies that manufacture and distribute food in the United States, with annual sales in excess of $280 billion. GMA has asked me to testify on their behalf because of my own background in this area, particularly because during 1971 to 1975, I was chief counsel for FDA and thus had direct experience in the very area that we're discussing today. I will summarize, in view of the time constraint, 6 primary concerns the GMA has with this pending legislation. The first concern is that no other agency of government has greater enforcement power than the Food and Drug Administration. Ed Dunkelberger has already summarized this statute. I would place extreme importance upon the strict criminal liability because that is the linchpin of federal enforcement of this law. But beyond even the straight court enforcement provisions that Ed just summarized, there are informal administrative authorities that FDA can use to even greater extent at times. Let me give you one: publicity. If the commissioner believes that an unsafe product is in the market, he can go to nationwide television and he will have that product off the market the next morning. He can issue warning letters. He can request recalls, as we know. He can indeed enforce not the guidelines of good manufacturing practice regulations. Those have been upheld in the courts as requirements of law for the food industry. Dr. Wolf is sadly misinformed about the status of those regulations. Thus, FDA has enormous, just enormous enforcement authority. The second concern we have is that, contrary to popular myth, and it is a myth, Mr. Chairman, FDA has been increasing its enforcement authorities if you just look at their own statistics. On page 12 of my prepared statement, I laid out the FDA enforcement statistics from 1940 to the present. In 1990, FDA, when you combine informal and formal enforcement statistics, had a greater number of enforcement activities than in any other year in FDA history. And thus, not only do they have adequate power now, but they are using it. The third concern is that there is no factual justification for increased enforcement powers for FDA over food, at least, at this time. There's no great history of fraud and abuse in the food industry, such as Chairman Dingell has found in the generic drug industry. There is no recent or sudden increase in food epidemics in the way of food poisoning or fraudulent claims. FDA itself emphasizes we have the safest, we have the most wholesome food supply in the world today. Our fourth concern relates to the fact that any problems that might exist today with FDA enforcement can be addressed administratively without any need for legislation. Commissioner Kessler took 2 recent steps that we applaud. First, he streamlined enforcement within his own agency, allowing cases to be brought quicker and more effectively. Second, he reinvigorated what used to be called regulatory letters, what are now called warning letters, took them back to the authority they had in the early 1970s. We agree with that. There is no need for legislation to do the kinds of things that he has done. Fifth, FDA does have real problems today, but they're not statutory problems relating to enforcement. In my 4 years when I was at the agency, I never once saw a single situation where a lack of statutory enforcement authority precluded FDA or hindered FDA from protecting the public health. No one from FDA today said that that was the situation. What the real problem is, what I saw then and what Dr. Kessler sees today and what the Edwards Commission saw, was all kinds of resource problems, lack of adequate personnel, lack of training for those people, lack of equipment in the field, poor science base, and in general, inadequate resources. This bill does not even begin to address those issues, and those are the real problems facing the agency. Finally, this bill runs the real danger of making matters worse, not better. Adequate enforcement requires mutual respect and cooperation. This bill would allow espionage by FDA using all the latest CIA electronic surveillance techniques, and that's right straight out of this statute. That is not a way to build respect and trust. That is not a way for an FDA, a modern science-based agency, to begin to work with the food industry to provide adequate enforcement.
Thank you very much, Mr. Hutt. Mr. Mannin?
Thank you, Mr. Chairman. I am Ted Mannin, Executive Vice President of the Health Industry Manufacturers Association, known as HEMA. With me today is Tom Long, HEMA's Director of Government Affairs, and we're very pleased to have this opportunity to testify on H.R. 2597. You have our written statement. I'll summarize that and in so doing leave the subcommittee with this one point. It is unnecessary to apply broad new enforcement requirements to medical devices because Congress already covered this same ground only 7 months ago. Let me explain that, beginning with a word of background. HEMA represents the manufacturers of medical devices, diagnostic products, and health information systems. Ours is an industry principally composed of small businesses. Within HEMA, 2/3 of the members have annual sales of less than $20 million. Device companies invest more than 6% of their revenues in R&D, about double the national average. And the fruits of this investment are innovations that save and improve lives. Now let me say something as clearly as I can. HEMA members support enforcement of the law, period. But let me be equally clear in saying why we oppose H.R. 2597. We oppose it because the Safe Medical Devices Act of 1990, put into effect just 7 months ago, has already given FDA many of the very enforcement tools we're talking about today. The new device law was more than 5 years in the making. It involved prolonged discussions that led to compromises on all sides. It resulted in nearly 50 pages of not very big print, a virtual rewrite of the FDA statute on medical devices, and it specifically gave FDA such new device enforcement tools as civil penalties, subpoenas, and recalls. Mr. Chairman, we simply know of no reason to undo, after 7 months, what it took 5 years to do. And in fact, what the pending bill would undo are several provisions carefully crafted with small business in mind. Now let me just try to illustrate this by pausing a moment on the important issue of civil penalties. Under the 1990 device law, FDA can impose civil penalties totaling up to $1 million per proceeding, a strong sanction by any measure. At the same time, these provisions were carefully molded to an industry composed of thousands of small companies. For example, distinct rules apply to violations of the so-called MDR and GMP regulations. Now, these are technical and sometimes ambiguous regulations on which even experts can disagree, and it can be particularly difficult for a small business to know whether a violation has occurred. In recognition of this, the new device law provides that civil penalties do not apply to these kinds of violations unless there is a public health risk or a significant or knowing departure from the regulatory requirements. Mr. Chairman, I've highlighted this area to show the kinds of provisions that the pending bill would simply toss aside. For under the bill, there would be no sensitivity to MDRs and GMPs. There would be no recognition of the other safeguards for small business, and there would be, in a word, no deference to the civil penalty provisions of the 1990 device law. Now, I can't leave civil penalties without noting that the pending legislation would substantially increase the monetary amount for which a device company could be liable. We simply know of nothing that has occurred in the last 7 months to justify such an increase. My final point today, Mr. Chairman, is that H.R. 2597 would not only undo provisions that were years in the making, it would also have the FDA undo the implementation of those provisions. We understand that FDA is now developing specific regulations on civil penalties, subpoenas, recalls, and other enforcement-related provisions of the 1990 device law. In anticipation of this, HEMA has convened workshops in which our members can hear directly from FDA headquarters and field personnel about the new enforcement rules. To come along now and to expand the requirements of the 1990 law would disrupt the implementation activities of both FDA and industry. It would mean confusion and delay, and it would make it less likely, not more likely, that small businesses will be able to understand and comply with the law. Moreover, I think this subcommittee well knows the thin resource margins at which the FDA operates. The last thing the agency needs now is false starts and new beginnings. What FDA does need is a continuing focus on the job Congress has already assigned it, implementing and enforcing the Safe Medical Devices Act of 1990. Mr. Chairman, that concludes our statement. We'd be happy to answer any questions.
Thank you very much, Mr. Menon. Mr. Mossinghoff?
Thank you, Mr. Chairman. Mr. Chairman, I'd ask that my full statement be placed in the record. It's a very brief statement, and I would like to focus just on 2 or 3 items. I'd like to associate myself with the remarks made by my colleagues here at the table. We believe that the PMA has been a leader in supporting strong and vigorous FDA over the past, since I've been at PMA, which is now 6.5 years. In that vein, we've supported increased resources and improved facilities for FDA and continue to do so. But we view this bill as not a means to revitalize FDA. The bill does not address the need for more scientists, modern computers, better management, improved facilities or working conditions. And in a narrow area of regulatory enforcement, the bill does not provide for more investigators or better training and management of existing investigators. It simply offers a whole new set of enforcement tools for FDA to use in unspecified and uncontrolled ways. We list the major items that we are concerned with, subpoena authority being one, and the question was asked repeatedly today, has there ever been a case where FDA violated trade secret rights? Well, our companies routinely submit trade secrets, and I think on that side of the FDA house we have no problem with their being able to protect trade secrets. We are concerned about the fact that last year Congress removed the prohibition it was in the law that said they couldn't provide that to Congress. And I don't believe, with all respect to Congress, I don't believe they're under the same safeguards that some of the FDA employees are. But I believe in the generic scandal, one of the allegations, or one of the proving allegations, was that one party's ANDA data were submitted to another ANDA, clearly a violation of that person's trade secret. So there are cases. Also, the subpoena authority, as we read it, is broad enough in this bill to reach patient records of those in clinical trials, including with names attached to those records, all of which has been off limits to FDA, and we're very concerned about that sweep. There's nothing in here to protect the clinical trial patient information that would clearly be within the sweep of the unlimited subpoena power. With respect to inspections, records, and reports, the idea that they could use photographic equipment, tape and video recorders, or other electronic devices, whatever that would encompass, clearly, in our view, would fall within the, quote, extraordinary methods, unquote, that Dr. Kessler indicated this morning that he would not be in favor of. I don't want to put words in his mouth, but I believe those kinds of authorities are clearly extraordinary. With respect to civil money penalties, the penalty of $1 million, I believe, is double, and there are a lot of food and drug lawyers in the room, and I'm not one of them, but there's virtually double what felony violations, intentional felony violations of the Act would subject a defendant to now. And then finally, with respect to the administrative embargo authority, as a government lawyer several years ago, we had no trouble with an agency getting temporary restraining orders from the courts. They were very, very well disposed to entertain properly brought requests for TROs, and sometimes within a matter of hours. In 1990, just last year, FDA did a comprehensive needs assessment through the year 1997, covers a wish list of everything they thought they needed to protect the public. In this comprehensive assessment, which specifically addressed enforcement policy, there's not one word of justification or desire to have the kind of authorities that's envisioned in H.R. 2597. I believe this was based on an appropriate and well thought out assessment of what the agency needed through the year 1997, and it did not need the authorities set forth in H.R. 2597. Thank you, Mr. Chairman.
Thank you very much, Mr. Mossinghoff. You've all opposed the provision of the bill granting the FDA additional subpoena power, yet most, if not all, other administrative agencies have subpoena authority comparable to that in the bill, including agencies such as the FTC, Federal Trade Commission, Consumer Product Safety Commission, Environmental Protection Agency, the United States Department of Agriculture, and OSHA, to which your companies may also be subject. Do any of the witnesses here have any specific examples to provide the subcommittee of abuses of subpoena authority by those agencies?
I'd like to point out one thing, if I may, Mr. Chairman, concerning subpoena authority. In my view, this is an example of the way the bill was drafted.
Excuse me. I have a question. And my question is, do you have a specific example of abuses of subpoena authority by those other agencies that have it?
No, I do not. But this authority is not the same that those other agencies have. That's the point I was.
You think it's a different authority?
Yes, sir.
Okay. If we adopted the subpoena authority that you understand those other agencies to have, would that eliminate your objections?
Well, we certainly would be willing to look at it as we would any provision.
The administrative...
Mr. Waxman, if you would like, we would be happy to provide information for the record as with regard to potential abuses of existing statutory authority.
Well, I
with other
gather you're all
agencies.
worried about potential abuses, but my question is whether you know of any actual abuses.
We will be happy to look into that.
Well, if you have any, we would like to receive that information. The Administrative Conference has recommended that all federal agencies be given subpoena authority. There are already more than 200 such statutes in federal law. Is there anything special about the Food and Drug Administration that justifies denying it its authority?
Mr. Waxman, it should be pointed out that FDA already has extraordinary factory inspection authority. It can enter without a search warrant. This proposal would simply add additional authority on existing authority that is quite adequate. There is no need for this kind of authority unless...
Is there anything special about FDA that should keep them from having the subpoena authority?
Yes, there is, and that is that it has a factory inspection authority without a search warrant, which has been pointed out repeatedly today is unique in American law.
Because FDA can go to a factory, does that mean it shouldn't be able to subpoena documents?
Yes, it does, in my judgment. The kind of industries we're talking about here are already extensively regulated. In addition, FDA is the only regulatory agency, as we have seen, that has the authority to impose strict criminal liability. If you add subpoena authority on top of strict criminal liability, you reach a point where the agency can obtain every document in every company, and they can go on fishing expeditions without search warrants and can probably make a case against every person in the food, drug, cosmetic industry.
Other agencies can use a subpoena and get other documents, and then if there's any criminal violation, that would be passed on to someone else.
But there would only be true if they proved willfulness, intent, or at least criminal negligence. None of those are required here.
Okay. The argument has been made that subpoena authority would allow FDA access to trade secrets. However, the agency handles trade secrets data every day. Can any of you provide examples of where agency employees have mishandled trade secret data, that is, of where they have inadvertently or otherwise released trade secret data?
Well, I think I addressed that in my opening statement, Mr. Chairman. I believe that one of the offenses in the generic scandal was the giving of one generic company of an ANDA of another generic company, which is clearly a criminal violation. I think the wrongdoers have been under existing authority. The wrongdoers have been caught and either are punished or in the process of the criminal investigations. I would cite that as an example of where there is not a totally clean record. Now, those were clearly wrongdoers, and I'm not trying in any way to tar the thousands of very fine people at the FDA.
Any other examples?
I would like to give examples, yes. There have been instances of inadvertent release of confidential information from internal FDA documents. My recollection is that there have also been one or two examples where FDA employees have been found guilty of violations of the statute. I don't have the specifics of those with me at the moment.
Well, we'll hold the record open.
Thank you.
If you want to submit that to us.
But, Mr. Waxman, there is a bigger problem here.
Excuse me, Mr. Hutt. I have only a very limited amount of time to answer questions. The agency, to ask questions, and then we'll hear the answers. The agency is a voluntary recall program in which all of your companies participate. The purpose of the recall provision in the bill is to give the agency this authority in the small but significant number of cases where companies do not cooperate. If your companies are voluntarily participating in recalls anyway, what objection do they have to giving FDA this authority?
The objection is quite simply this. Is under current law, if a company does not make a requested recall by the FDA, the agency can go to court, prosecute criminally, seek an injunction or a seizure, and the issue will be determined whether there was a violation by a judge. The way this statute is drafted, the agency could order a recall on its own, And the bill makes the violation of the order a criminal violation. In other words, you don't even get a chance to test whether there was a legitimate position taken by the agency. The issue is, should you have action first and then judicial involvement, or should you have a very substantial burden imposed through judicial authority? That's as very simply as we see it.
And if there were a recall authority that the company disagreed with, I would assume there would be a recourse to the courts immediately, wouldn't there?
Immediately. How soon? You'd have to find your way all the way to find a court. In the meantime, you will have violated the order, because presumably a recall order is only going to be issued if the agency feels something has to be done. The bill could hardly be more explicit. Failure to observe a recall order from the first moment it is given is a criminal violation.
Mr. Lant?
Thank you, Mr. Chairman. I'd like to welcome the witnesses to the panel. Mr. Hutt, as I understand it, you've been involved in food and drug law for more than 30 years.
Yes,
and
sir.
I think you indicated that for several years you were the chief counsel for the Food and Drug Administration. Is that correct?
Yes, sir. From 1971
and you
to
teach,
1975.
you teach food and drug law in law schools currently, or have you done that in the past?
Yes, sir, I do, and I am the co-author of the casebook used to teach food and drug law in law schools throughout the country today.
More than one law school, this book is used?
It's used in up to 40 law schools. If I can put a plug in for it, the second edition is due out any day, and I'd be delighted to sell it to anyone.
I'm going to recommend counsel on both sides of the aisle buy a copy. I guess the gist of your testimony is that we don't need this bill. What we need instead are things like adequate personnel and better training, more equipment, and that will, in effect, be the answer to the problems that the FDA has.
Yes, sir. I believe every one of the organizations at this table has testified in favor of greater FDA appropriations, greater numbers of personnel, higher budget, so that the agency can do an effective job.
Okay. Now, let's just focus on this whole question of subpoena power. Well, we're told, for example, that there are all these other agencies out there that have subpoena power, and therefore, why does the FDA resist, or why do you people representing the industry resist giving the FDA these subpoena powers that are allegedly commonly used by other administrative agencies of the government? Isn't it the fact that those agencies, those other agencies that have this subpoena power, do not contain, they don't have the authority to be subjected to strict criminal liability standards without any proof of intent or knowledge? Is that the case?
Mr. Dunkelberger and I have both pointed out that FDA, along with USDA, which has, of course, an identical statute, is the only government agency that can impose jail sentences on individuals who have no knowledge or intent of the illegal activity. And that is why both increased factory and inspection and subpoena power do not belong in this context.
So that an agency like the Federal Trade Commission, which has subpoena power, does not have the ability to subject an individual to a strict criminal liability standard without any proof of intent or knowledge.
That is correct, sir.
Okay, I'm not going to ask.
If I might add,
yes, sir.
One interesting thing that this statute again distinguishes the subpoena power from that granted to the FTC. As far as I'm aware, the way you enforce a subpoena in every other agency that I'm aware, the agency goes to court after issuing the subpoena, it's not been observed, gets a court order, and then if you violate the court order, it's contempt of court. The draftsman put that provision in, but then put in another provision that said the failure to obey a subpoena is itself a crime. Again, it seems to be that just the failure to obey the FDA subpoena without court intervention is itself a crime.
There's a sentence in your testimony, Mr. Hutt, in which you say, quote, "The FD&C Act imposes the most stringent penalties of any federal law. It is easier for FDA to convict a food company or its officials of a violation of the FD&C Act than it is for the Drug Enforcement Agency to convict a cocaine dealer of a violation of the Controlled Substances Act.
That's absolutely true.
And that's without this new law, in your opinion?
That is correct, because there is no requirement, again, to show willfulness, to show intent, to show knowledge in order to convict the chief executive officer of a food company of a violation of the Federal Food, Drug, and Cosmetic Act. In order to convict a cocaine dealer, one must show knowledge and intent to violate the Controlled Substances Act.
Okay, well, I'm glad you made that point. Let me ask you this. Do state health officials have, I'll just finish the sentence, have embargo authority similar to the provisions in H.R. 2597?
Some do, some do not.
Okay.
And there are different forms of administrative requirements that provide additional protection under some of the state laws.
Thank you, Mr. Chairman. Thank you.
Thank you, Mr. Lent. Dr. Rowling?
Thank you, Mr. Chairman. Let me ask you, I believe you said earlier that FDA could increase its enforcement activity administratively.
Yes, sir, I did.
Okay. Well, can FDA do administratively, or could it do administratively what is would be required statutorily in the legislation before us?
Let me explain exactly what I mean by that. Let us take a violative product that is out on the market.
Oh, I have.
And there were examples of that given this morning. In not one of those examples is there currently inadequate statutory authority for FDA to protect the public health. Not one of them this morning. If a violative product is out there, here are the various things a commissioner could do. If there's a sufficient threat to public health, the commissioner can go on nationwide television, and as we have seen, even with as trivial an issue as the definition of the word fresh, those products will be off the market the next morning. Failing that, the commissioner can go to the company and say, either you recall or we institute multiple seizures today. Failing that, the commissioner can go, as Mr. Mosinghoff suggested, and get an injunction against any further shipment or dealing with that product. And then the commissioner can look the chief executive officer in the eye and say, if you do nothing, I'm going to bring a criminal case against you personally, and we're going to try to put you in jail. Now, if that isn't strong enforcement, sir, I do not know what is.
But FDA at present cannot, for example, and we take the food industry, inspect container manufacturers if there was some reason to suspect a problem.
If there is reason to suspect a problem, or even if there is no reason to suspect a problem, any FDA inspector without a search warrant is entitled to show up at the factory merely to present credentials and then to obtain entry. That inspector can stay in that factory as long as is necessary to observe any practices. The inspector has no statutory right to see records. What in fact occurs, sir, is that the inspector will frequently ask to see records, and if there is a good reason to do so, the plant will quite frequently, if not almost always, provide those records. Only in rare instances are those records not voluntarily given where there's good reason. Now, what frequently happens is an inspector will come in, ask for records, and give no reason. And at that point, if he's on a fishing expedition, the company will frequently say, if you can't give a reason for wanting to see these, we're not going to just shovel all our records into your FDA files. But if you do have a good reason, we're willing to consider it, and as I say, the rule rather than the exception is to cooperate. After all, this statute only works through cooperation. As I said, it only works through trust. Otherwise, we would have a breakdown in the law totally if the industry did not cooperate. Commissioner Kessler said that this morning.
I could add that the National Food Processors Association has been through in the past situations where products seem to create a public health risk. The association was immediately cooperating with the agency in a matter of minutes and sharing with the agency questions of the distribution of the product, what the processing records, Clearly, when there's a question of public health involved, as far as I know, the food industry cooperates.
You don't know of any instances when a request for records, for example, were denied if there was some cause to suspect there may have been a problem?
I'm personally unaware of any, not a single one.
Certainly in which their public health was clearly involved or implicated in some fashion. I'm not aware. And if there had been any such situation, and if the FDA didn't follow up in the strongest possible way with effective enforcement action, then it seemed to me the agency was wanting.
Indeed, if the agency did not follow up with the kind of enforcement we have been discussing this afternoon, it would be a pretty clear indication there was no significant public health issue. One must remember that this statute deals with many, many questions involving only economic regulation, not health and safety regulation. It is quite literally a criminal violation of this statute to misspell one of the words in the statement of ingredients on a food product or to leave the zip code off the name and address of the manufacturer. That's a criminal violation of law. Now, hopefully there never will be criminal sanctions imposed for that, but we're dealing with a very stringent statute.
Thank you. My time expired.
Thank you, Dr. Rowland. Mr. Hester.
Well, thank you, Mr. Chairman. This morning, when we were talking to the FDA, we talked about proprietary information. Are there provisions, Dr. Hutt, in the Food and Drug Cosmetic Act or other laws that would protect proprietary information under this bill?
Under this bill, there is no protection of proprietary information, but under the general provisions, Section 301J of the Federal Food, Drug, and Cosmetic Act, it is a criminal violation of law for an FDA employee to release confidential information. Let me explain the practical problem that we face. Suppose that I am a soft drink manufacturer and I have a secret formula that I do not even let my own employees know about, which is true throughout the industry. I keep it locked up in a safe, and only myself and one other person, in case I die, one other person has access to that formula. That formula under this bill could be given to every FDA inspector. It could appear in establishment inspection reports and internal FDA documents. 8,000 FDA employees could have access to it. And if at some point it later turned up in the public area, how would I ever know how it was inadvertently released? That's no protection to me at all.
I had an example in my district of a baking concern, national manufacturer, that keeps very, very stringent records, quality control, procedures, records, first of all, to keep its quality control, to learn from. If this law was passed, is it possible that concerns like that would do away with records or not keep such stringent records because those records could be confiscated?
All of those records would be available either by factory inspection or by subpoena under this bill, which is what we are concerned about. FDA currently recognizes itself that the concern you have raised is a serious concern. FDA has internal rules at the moment, which would be changed by this bill, which say that when you do your own internal quality control check, that FDA will not ask for that under the law, even where it has the legal right to get it, as with respect to prescription devices and prescription drugs, because of the very concern that you raise, that companies would stop doing their own internal quality control checks for fear they'd be hanging themselves. That would be obviously counterproductive to adequate law enforcement.
Many food companies, I might add, that produce products out of the fields that are naturally associated with dirt, they've been grown in the dirt, it's a matter of trying to get as little contamination as possible. A conscientious quality control program with its own records was intended to reduce and to a minimum those technical violations, and yet those very records will themselves, once discovered, will disclose violations. Now, again, we don't expect the FDA to be prosecuting people for those violations, but the fact is the exposure is there, and whether companies be willing to take the risk or not is an individual decision that companies will have to make.
All of a sudden becomes some interesting linkage and other testimony that we've had in here, and Mr. Chairman, won't get into that today, but we'll talk about that later. Mr. Hutt, in your experience as FDA General Counsel, what happens when a company refuses to go along with a voluntary recall?
The entire food, drug, and cosmetic, as well as medical device industry, learned a strong lesson in the late 1960s when modern recall requests began. And I don't remember the exact year, but it may have been 1969, when FDA discovered that one of the leading national brands of non-fat dry milk contained salmonella. The commissioner personally asked the president of the company to recall the product. He declined to do so. That night, the commissioner went on television, told the entire American public that the product was contaminated. I need hardly point out the result. The result was the next day that product could not be found on the food shelves of any store in America. Moreover, after it was forced off the market, the company decided never again to return to the market with that brand name because it had been destroyed. Now, the industry learned you only refuse a recall when you are on solid ground, when you know you're right, when you know that FDA is wrong, and then you go in and work it out with the agency and convince them. But if you refuse to recall where the agency is right, you're going to lose your product and potentially face criminal liability as well.
Thank you, Mr. Chairman.
Thank you, Mr. Hastert. The issue of an embargo authority is, as I understand it, for FDA to say, let's put a hold while they go in and get a court order if they see that there's a problem with a product. And Mr. Hutt, you indicated some states have such authority, other states don't. For those states that have this embargo authority, have they produced industry problems?
On occasion they have, on occasion they have not, Mr. Waxman. I don't think there is any rule of thumb on these situations.
Well, you're concerned about the FDA having the authority that other states, that some of the states have.
Yes, sir, we are.
If it's not a problem with those states that have that authority, why do you think there'll be a problem with FDA having that authority?
Please remember that the legislation that is being considered here would give that authority to every FDA employee. Every FDA employee. There is no distinction made in this bill between the commissioner and anyone else in the agency. And thus our concern is, whether it be perishable food or even any other type of food, an FDA employee can walk into a food plant.
So your concern is about too many employees at FDA having this authority?
Well, not just too many employees, but the ability of people, even if it were at a mid-level, to be able literally to put a company out of business by embargoing everything they have, even when there is no health and safety issue.
Well, one of the witnesses this morning who was involved in enforcement at FDA said before they could get some action by a court to stop a product that was, they thought, a threat to public health, it was already sold because they couldn't move and issue an embargo by themselves. They had to run to a state if the state had the embargo authority or get some court action. That's, I think, the problem that we're concerned about. Let me move on. FDA acknowledges that one of the most resource-intensive aspects of its current enforcement efforts is the gathering of evidence to prove that a product is in interstate commerce. Mr. Hutt has acknowledged that this question is rarely, if ever, raised by the industry, but it's clear that FDA must create a full paper trail or risk being thrown out of court. What good does it do to require FDA to go through those efforts? If you all acknowledge that the agency is short on resources, why shouldn't the standard be whether a product affects interstate commerce?
NFPA does not oppose that provision. I will add, though, it expands FDA jurisdiction. It's exactly at odds with the claimed purpose. Right now, the FDA jurisdiction is limited to goods moving across state lines. This would expand FDA's jurisdiction tremendously over local California food operations. I don't understand how this can reasonably be put forward as a as saving resources. It'll save some paper shuffling, but it will expand the FDA's enforcement jurisdiction very substantially.
If I grew an apple on my tree and ate it on my own table, it would now be subject to FDA's jurisdiction.
Do you agree with the premise that there is a tremendous amount of resources that are used and, in some sense, wasted to establish the interstate commerce provisions, and that there ought to be a streamlined way for FDA to go through and make that case and make that showing in order to proceed?
I said we would not oppose that.
Mr. Waxman, we're dealing with two different provisions in the draft legislation, in the proposed legislation. The first one is the one that would expand jurisdiction over all commerce. That is the one that creates the biggest problem. If there were a presumption, a rebuttable presumption of interstate commerce, that would create less of a problem because it would not involve my apple being sold at my roadside stand, which clearly doesn't involve interstate commerce.
I appreciate
it's
that.
the affecting interstate commerce that creates the major problem.
Thank you. Mr. Dunkelberger, you've argued that a records inspection authority for FDA will discourage the best companies from keeping records of quality control. I find it implausible that food processors won't want to keep such records for their own quality, or that the best companies have so much to hide that they'd rather know nothing at all, running the risk of genuine quality problems. But let me assume that you're right for the moment, that companies fearing the FDA's only current remedy, current criminal sanctions, might abandon records. Might this problem be made a little bit more balanced if the FDA didn't have to choose between criminal sanctions and nothing, if, for instance, they could seek a nominal civil penalty instead?
Well, I don't think the civil penalties is in a very simple way. Civil penalties call for administrative hearings. Every civil penalty that you're going to impose, that you're taking out of the courts.
Well, you certainly don't want civil penalties imposed without an opportunity for hearing.
We would like them, if you're going to have them, impose them through the courts. What's wrong with that?
So you have no problem with civil penalties. It's a question of who imposes them.
Right now we have criminal penalties through the courts. I think if you're going to have more penalties, have the courts impose them.
Okay. Mr. Lamb.
Are you aware, Mr. Hutt, of the FDA's current policy on the use of electronic devices?
The FDA's current policy was adopted in the early 1970s when the agency made a determination that it would no longer use secret tape recorders.
There had been a period when they did use them.
During the 1960s, they did authorize inspectors to carry briefcases containing hidden tape recorders into interview situations. That was the subject, as was brought up this morning, of congressional hearings and a great deal of controversy. And in the early 1970s, the agency took the administrative position that that was simply unconscionable and they would no longer do it. That remains, to my knowledge, the policy today.
Now, this legislation that's before us, as I understand it, would authorize the use of these tape recorders and cameras and so forth. Is that not correct?
As I indicated earlier, in my judgment, it goes much further than that. It allows any electronic surveillance as long as an inspector first presents credentials. That includes bugging of telephones, leaving electronic surveillance under a table after you've been to a meeting, sitting across in a plain-colored van and listening in on telephone conversations. Anything the CIA has today could be used by FDA under this provision. And we find that absolutely intolerable.
A number of examples were referred to this morning in which it was suggested that products remained on the market which were dangerous to health, and yet the company refused a recall. Doesn't the FDA have criminal seizure and injunction authority that should have been used if, in fact, there was a danger to public health?
Mr. Land, if there was a danger to public health, I am convinced FDA would have used that authority. Commissioner Kessler said that this morning. He said, we have adequate authority to enforce the law today. And I agree totally with him.
Okay. Now, one last question. Proponents of the bill have repeatedly stated today that this legislation would merely bring FDA up to the level of other enforcement agencies. Isn't it the case that in virtually every section, important citizen safeguards have been deliberately eliminated for recalls, embargo, civil penalties, inspection, subpoena, the whole gamut of things that the ACLU and the Magna Carta, whole deal, have been trampled upon in this legislation?
That is one of our principal concerns.
I don't know of any other federal regulatory agency that would have the authorities that the FDA would have after enactment of this bill. No other agency would have the full collection. I mean, some have different provisions. Some have embargo. Some have administrative recall. Some have civil penalties. All of them have more administrative safeguards in terms of a standard to be met, a opportunity for due process. All of them have more safeguards than are included in this bill.
Yeah.
As far as I see, this doesn't bring the FDA up to the level of other agencies. It takes it far beyond, in my opinion.
Is my time up, Mr. Chairman?
No.
Oh, well, one last question then. Now I'm getting close to home. In the next congressional district from mine, there's a Bob Mrazek's district, there's a firm that makes distributes Riunite wine. It was a favorite wine. Not the FDA, but I think it was the Tobacco and Customs, improperly lumped Riunite in with a bunch of other winemakers as having some sort of toxic substance in the wine. And when they went on television, Meryl Streep or whoever it was, you know, one of the authorities on this kind of thing, they always showed the Riunite up close. The last conversation I had with these people, Riunite is selling today, and this is years later, at about 30% of what it was selling in its heyday before it was erroneously looped into this. Is there any provision out there in the FDA law for compensation for those citizens of our country who are wrongfully spotlighted by publicity or by actions of the FDA or any of these other federal agencies?
There is currently no such provision in the Federal Food, Drug, and Cosmetic Act, and it is, on occasion, a serious problem where FDA, not maliciously, but inadvertently makes a mistake, requires a recall, brings a seizure, issues publicity that harms a company, and there can be a tremendous economic loss that it goes uncompensated.
Yeah. Thank you, Mr. Chairman.
Mr. Hastert, any further questions?
Thank you, Mr. Chairman. Yeah, I grew up in the food business, and I guess I take a little bit of different view of it. I learned in that business that, first of all, hard work and reputation, building a customer base, is everything that a food business has to base its reputation on. As a matter of fact, it may do some pricing and advertising, but over a long term, that reputation is what you have to stand on. And it's a pretty thin line when you have somebody that can go on TV and say that this product isn't good and it should be recalled as of the FDA chief, or be attacked in public, and all of a sudden you can have literally years and years and years of hard work wiped out. And a small food company and some big food companies can be wiped out with that type. And so I guess where I'm driving at, there is a liability issue out there. It's a liability that any individual can come out and sue you for, having a black lima bean in the pot or whatever. There's that type of civil liability. There's the civil liability that the FDA has, plus criminal liability, plus just the reputation of a company that's at stake in all these issues. What are the advantages and disadvantages, in your view, of the strict criminal liability under the standard under the Food and Drug Cosmetic Act?
Well, I grew up in the food business also, and spent 8 summers delivering milk on the streets of Buffalo, New York. So I share your same view. Reputation is what sells products, and you lose your reputation. I think it's true of medical devices and prescription drugs as well, and you have lost your business. The strict criminal liability has, and I will be very straightforward here, has some great advantages for the regulated industry in one respect. It forces people to focus on compliance and doing an adequate job for the protection of the public health. In and of itself, without other onerous enforcement provisions, one can understand that. But if you then add on strict criminal liability, increased factory inspection, fishing expeditions, electronic surveillance, there isn't anyone in the country in the food, drug, or cosmetic business that won't go to jail. Because technical violations of the law are commonplace, as you know, from your own background in the food industry. As I said, if I forget to put the right zip code on my name and address on the package, that's a criminal violation of law. If there is one violation of the good manufacturing practice regulations, if some employee slips up inadvertently, even if there's no health and safety problem, that's a violation of the statute that can result in criminal penalties. So while we want high standards right straight across the regulated industry, we don't want draconian enforcement that is going to result in overzealous putting of people in jail, putting products off the market, embargoes, recalls, and the other kind of thing that we're addressing today.
Well, I realize that I would say, 95, 98, 98.5%, maybe 99 and 9/10% of the people in the food and drug and cosmetic industry are reputable people. And sometimes they get carried away in competition and advertising and claims, and I think the FDA has shown that they certainly can use their arm in those types of situations. But I also recognize what the chairman of this committee is trying to do, and to make sure that our food supply has the highest dependability. I think it already has the highest dependability in the world, but even better than that. And how do you strike, in your view, a moderation of what this act has and what the status quo is?
I think this act provides extraordinarily strong, effective enforcement provisions. It already strikes a strong balance. We did not hear the Commissioner come up here today and say that he could not take unsafe products off the market. He said, when pushed, that whenever there is a problem of public health in this country involving foods, drugs, devices, and cosmetics, he has the authority, the statutory authority, to take action. To me, that is the most important thing, and it ought to be reassuring both for this committee and for the public.
Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Hastert. In other words, the answer to Mr. Hastert's question is you want the status quo.
We want the statute enforced.
You want the status quo, and you don't want any changes in the statute. Just to complete the rounds here, I had some contact with the food industry as well because we lived on top of my father's grocery store. But there are hundreds of recalls that take place not only in the food but the drug, cosmetic areas. Every year, almost all of them are done through voluntary recalls. I don't think that that will change. What I heard the Commissioner saying this morning is that he didn't, I hear him say that he doesn't want it, the status quo as you want it. He wants some tools that will give him the ability to make sure the law is carried out. I think this is a remarkable quote to Mr. Hutt as the representative of the Grocery Manufacturers Association. There isn't anyone in the food industry who isn't going to jail. You said that a few minutes ago. Obviously, that's an exaggeration.
I didn't say who isn't, who couldn't be criminally prosecuted for a violation, a technical violation of the statute. Well, if you want increased enforcement powers, then I suggest the remedy is to require knowing and willful action before there is any violation of law, and that is indeed what the Carter administration recommended in 1978 when it first raised the question of revising.
I want to assure you that it's not our purpose, and I don't think it's Commissioner Kessler's idea either, that we ought to be prosecuting people for very minor, insignificant, trivial kinds of violations of the law, of misspelling a word or whatever.
Well, then there's no reason not to change the statute to put that in.
Well, I don't think we're changing the statute to say that there's going to be a prosecution for every minor violation of the law. Whatever prosecutions can now occur under a standard with which you would like to have changed, because that's existing law. You want to roll back the status quo. That prosecution is possible now. We don't see prosecutions for every violation of the law under the FDA Act, do we?
We don't see any protection in the statute that says that can't occur, and if you agree that there should be no criminal prosecution for that kind of thing, I think that should be written into the statute.
Well, this is a debate that's going to lead us, it seems to me, nowhere productive. If you wanted something in the law saying that the commissioner should not have prosecutorial discretion, but he should be barred from prosecuting something that is trivial, then I suppose you've then got to define trivial and all of that. I think we can trust the good judgment. I'm thinking, I'm stating, I'm not asking. I think we can trust the good judgment of the commissioner of the FDA to use the law properly. What I want to say to my colleagues on this committee and to all of you at this table is that I hope we can look for a way to think through together how the commissioner can have the authority he thinks he needs, make sure the law works the way we want it to work, and all these extreme kinds of examples I don't think are realistic reasons why we shouldn't even tackle this question. I don't believe that people in the food industry are going to be prosecuted for trivial violations of law, nor they should they. And let's put that out right now as a red herring that we can put back in the stream. I want to thank you for your participation. We'll look forward to talking with you, if not, in fact, working with you on this legislation. That completes our hearing today. We stand adjourned. Chairman.
That concludes our coverage of this hearing of the House Energy Subcommittee on Health and the Environment. For more information, write to the subcommittee at 2415 Rayburn House Office Building, Washington, D.C. 20515. And be with us later this morning for debate from Tuesday's session of the Senate, as senators discuss the availability of abortion information at federally funded family planning clinics. That's later at 8:40 Eastern Time, 5:40 a.m. on the West Coast, here on C-SPAN 2. Up next, Democratic Congressman Steny Hoyer of Maryland discussing U.S. aid to the Soviet Union.
Good morning.